If it wasn't Mr. Spacey, he never would have filed the case? Is that the translation?
I think you've had way too many questions that have gone
Sir,
too
listen
far.
to me. You keep this up, I'm going to hold you in contempt. This is a criminal proceeding, and you will cooperate, or as I say, you'll be held in contempt.
I understand.
When did you first notify the police about these allegations that you've made? About a year and 3 months after the event.
Yes.
I mean, you didn't go to the police the next day,
No.
the next month.
No.
You didn't even go within the next year, did you?
I don't believe so.
This case needs to be dismissed, and I believe it needs to be dismissed today.
The data that she told me she altered had to do with frat boy activities.
And they actually objected to us getting the phone. It's outrageous. How could they conceivably do that knowing what they knew? If the allegations are untrue, every bit of data is relevant, ma'am.
The allegations are not untrue.
We'll see. But if she's gone through and scrubbed that phone to make him look like some sort of choir boy, and Mr. Glennie already knows, and he should be concerned that his extraction report is inaccurate, because that's the big issue in front of the court.
I believe I was raised to tell the truth and not be afraid to.
This is big, bold, new news. It's new to us. It's new to the court. The problem is it's not new to them. You remember giving a press conference,
Yes,
obviously. What's on the table next to him?
beer cans. It doesn't make him a criminal.
I didn't ask you if it even made him a criminal. I think it's outrageous. I think it's unjustified, and it's not fun. Did you have a conversation with your wife at any point between then and now
No.
about, well, let me finish my question.
I know what your question is. Go ahead.
Well, you don't know what my question is. I don't make these points lightly. It is not fun for me. This is not enjoyment for me.
I've never done it, so I don't know.
Bless your heart, me neither. Wouldn't want to. But that's what he's doing, correct?
Well, I can see some deleted items and I can see things that basically weren't deleted that looked like frat boy activities. So my first thought was probably not the best job of deleting things.
Period. Full stop. Well, she's not in the room now, I hope. She's the only one among us who knows what those, quote, frat boy activities are. Trooper Donovan certainly didn't.
I'm sick.
The reason for Venmoing you this money is, and someone would say prostitution. I said, what the hell is this?
And then you deleted it.
I don't know if I deleted that. No. Let's be clear about something. That was later. That was later. He was getting high. He had a water pipe of some sort and he was getting high.
He told an officer of the court, me, something that he knew to be completely false. That was a blatant falsehood.
Looking at what's in the phone, or are you talking about what's happening in the real world of what's happened here?
Are you kidding?
The phone was not the issue.
Let me finish. It'd be one thing if all of us were fooled by the Unruh family. The Commonwealth wasn't fooled. They had all this information. If the court could accommodate us in August, even late August.
No, it can't. It's difficult enough to get accommodations on this island. Well, it would be impossible to get this case tried.
Stay in a tent.
Well, I'm glad to know that, but
Get accommodations or lax, but we'll make do, Judge.
I
The horse is, if it's not dead, it's on its last leg, and I don't want to beat it.
consider the horse dead with respect to a trial in August. So
I was hoping you weren't going to say that. This is a ridiculous case, and they shouldn't have filed it to begin with. But they did it. They unlocked that barn door, and now the horse is out, and they've got to go to trial.
We're all right. The court's back in session. Maybe seated.
folks made a statement earlier. It probably bears repeating. While you're all welcome to sit here and observe, no one should interfere or interrupt these proceedings. If you do, you risk being held in contempt, which carries a fine or even incarceration in some cases, or certainly being removed from the courtroom. But you cannot take pictures or record. Madam Clerk, go ahead.
Certainly. 1888 CR 0598, Commonwealth versus Kevin S. Fowler. This is an arraignment, Your Honor.
Thank you. All right.
No record.
Play, please.
Thank you.
Okay, Mr. Fowler, this complaint charges that in the town of Nantucket on July 8th, 2016, did commit indecent assault and battery on person 14 or over.
Sir, if you're charged with another offense while this matter is open, you can be held for 90 days without bail. Mr. DA, request beyond the bail warning, any?
Beyond the bail warning, Your Honor, the Commonwealth is requesting that Mr. Spacey be ordered to stay away and have no contact with the named victim and his family.
All right, certainly the court will impose those conditions. Anything additional?
No, Judge.
Okay. All right. No requests in terms of movement or staying within the United States, anything?
As
Nothing?
required by the court judge and as required by the probation department, our only request specifically is the stay away.
Okay. All right. Well, those will be the conditions then. Sir, you'll meet with probation. You'll sign those conditions. You'll be required to stay away and have no contact, direct or indirect, with the alleged victim. All right. I know there was a motion filed by defense. I had occasion to look at it. Mr. DA, have you had occasion to look at it?
We've reviewed them, yes, Judge.
Okay. You want to be heard on the motion or?
Briefly, Judge, regarding the motions to preserve, we agree that anything that is currently in our custody and control, we have to preserve, we will preserve, and we will turn over in discovery.
Sure.
As it relates to the motion to preserve itself, we're suggesting at this point that the scope that is being requested by counsel is overly broad. It's asking for July 7th and July 8th of 2016, but all the way up to the present. We suggest that based on what's been filed up to the present is overly broad. The affidavits in the motion suggest that Mr. Little and his girlfriend or another individual were texting contemporaneously on the 7th into the 8th. And then it says by providing this other information, we'll likely see that something happened or that he talked about it further. But there's no basis for that information within the motion to preserve. We would suggest that it's a fishing expedition at this point and that the motion should be narrowed at least to the 7th and 8th of July of 2016.
It's a fair point. Mr. Jackson or Ms. Bolero, I don't know who's going to respond, but feel free.
I'll be happy to respond. Alan Jackson on behalf of Mr. Spacey.
Sure.
Your Honor, I don't believe at this point that we need to talk about the scope. That's something in terms of a subpoena. In other words, what I subpoena or what I serve on those individuals might require a discussion or some litigation about the scope. All I'm asking at this point is that we preserve it. In other words, this is data that we believe is not only potentially exculpatory, but likely exculpatory for Mr. Spacey. I simply don't want to see any of that data deleted, destroyed, even inadvertently, or in other words, in any other way manipulated. I don't think it's a burden at all on the Commonwealth, nor on the two individuals named in the motion, MD and the complaining witness, to simply say, I'm ordering you not to destroy anything so that Mr. Jackson, Ms. Bolero, the Commonwealth can litigate in front of the court at some point whether or not there is exculpatory information that leads all the way up to today. In other words, all I'm asking for is just to put a bubble around that data so it doesn't get destroyed. I'm not saying I get it yet. I just don't want it destroyed yet.
Further response?
We can only control, Judge, at this point, what's in the care, custody, and control of the Commonwealth.
Right.
As far as information that would be contained within the specific service providers of these individual cell phone carriers, well, that's different. We have no control over that, Judge. So we would suggest that as far as the preservation goes, whether it be to the individuals directly or to the providers, that it be limited at this point to the 7th and the 8th until more information can be provided as to why it might likely be exculpatory versus a fishing expedition.
Right. I haven't seen any of the police reports, so I don't know what, except for your affidavit, I don't know what information that you base this request upon. I do think that the 7th and 8th certainly it would be appropriate to time span to preserve the evidence. But I understand that even if the motion is allowed, it can be modified down the road and can be tightened up. And so I'm inclined to allow the motion. I don't know that I'm going to do it all the way up until, from the 7th and 8th up. I mean, I may give you maybe 6 months worth of preservation, but I don't know that I'm going to require that everything be preserved. Go ahead.
Certainly at this point, that would be satisfactory. 6 months worth of preservation, I think, is better than nothing. And I'm certainly willing to accommodate the Commonwealth and the courts. Yeah.
All right. So from was it July 7th?
July 7 and 8 of 2016.
Okay.
And 6 months thereafter.
All right. 6 months thereafter, the motion will be allowed. At least there'll be a requirement that the cell phones and I think the cloud-based and then some passwords, et cetera, that all be preserved. As I say, that's subject to further modification one way or the other, depending upon what is discovered during the course of this matter. So,
thank you.
All right. We have a further date, gents and ladies that work. Sir, you can be seated. You don't need to continue to stand. Thank you. Thanks. Actually,
Your Honor, Mr. Jackson is admitted pro hac vice. I am local counsel on the case. Are you going to require my appearance from someone from my office at all proceedings?
Are you in already? I know you came in so that he could enter the pro hac vice, but
I do have a notice of appearance on file, and Mr. Jackson was filing one today as well.
so your appearance is already in.
My appearance is in.
We'll leave it there. Thank you.
Your Honor, if it pleases the court, counsel and I have discussed informally a date of the 4th of March, which is a Monday. I understand that's most convenient for the court.
That's right. That's jury week is in February, so March 4th would probably work.
And counsel and I also discussed off the record, and I would ask for the court's guidance on this. He has no objection. The Commonwealth has no objections. Mr. Spacey not making that appearance. I can make that appearance on his behalf, along with Ms. Valero, if need be, without him having to be there on that date.
No, and that's fine. His appearance can be waived. However, he should be, the rule requires that he be available, so he should at least be on the other end of the phone if there's some reason that he needs to be contacted, but his appearance can be waived.
Okay.
Sure.
Thank you.
And
Thank
can
you.
we schedule that, Your Honor, for 11 a.m. again?
Sure. All set? Anything additional, folks?
I don't think so, Your Honor.
No? All right. Thank you all for your help. I'm going to step off, and then the camera people can break down their equipment, and those connected with the case can depart. Thank you very much.
Okay, this case has been continued to March 4th, 2019 for pretrial hearing at 11 a.m. The defendant's appearance has been waived. Sir, you should report to the probation department before you leave the building in order to sign the conditions of stay away and no contact with the victim and the victim. Thank you.
Court can be recessed. Kevin, do you see just one minute on the charge of today? They happened. What are your feelings today, Mr. Spacey? Mr. Spacey? Well, there shouldn't be.
Folks.
What do you got?
This is Commonwealth versus Kevin S. Fowler.
Gentlemen, thank you. I reviewed the pleadings. Mr. Glennie, I haven't had a chance to go through your response completely, the exhibits, et cetera, some of which I'm familiar with, others I may not be, but we'll go forward with the arguments. And my hope is that I am here all week, so I will issue a written ruling on this matters, and hopefully that can be done this week if the jury trial is scheduled to break down and give me a chance to do that. As I said, I've looked at the pleadings. I'm also aware that there was a protective order that apparently has been signed by the parties. I don't know whether that was signed this morning or it's not dated, which seems to, I guess this applies to the extraction completed by the Commonwealth of Mr. Little's phone. Is that right?
Yes, Your Honor. My understanding is, I don't know when, but they brought their signed portion of it today.
Sure.
We signed our portion today.
Okay.
So when they signed it, I don't know, but it was signed for the court today.
So is this copy that I have the one that both parties have signed?
Yes.
That's right.
And is it both your desires that I endorse this and this become the protective order that it's going to apply in this case?
So submitted.
Yes?
Yes.
Okay, I'll do that and I'll date it today. Sir, Mr. Jackson, you're still going forward on your request for a forensic download performed by your expert of the phone itself. Is that right, sir?
Correct.
Okay, and I think I saw, Mr. Glennie, in your response that the phone has been turned back over to either Mr. Little or his mother. Is that right?
That is correct.
Can you tell me when did your office complete the extraction in this case?
There was, I believe it was in November.
And when was the phone turned back over to?
November.
Actually turned back over in December of 2017, December 18th, 2017, which we've just learned. So they had the phone, the actual physical phone, for a little better than 2 weeks, 2.5 weeks or so.
Okay. All right. So the phone was turned back over to the owner in advance of the case being filed and any orders that I issued pertaining to preservation of evidence, et cetera.
A
Yes.
year and a half in advance.
Okay. All right. I understand. All right. Why don't we proceed? And Mr. Jackson, if you want to address me concerning your requests, I'm happy to hear you, and then I'll hear, Glennie, your response.
Your Honor, there's 3 or 4 points that I want to make broader on a broad scale, 3 or 4 points that I want to make today. And I want to start with probably the most troubling. There are several troubling aspects of what's been going on up to this point, but the zenith of those is misrepresentations that were made by the Commonwealth to the defense, very specifically as they relate to Will Little's phone. Just to go back and to cover some dates, January 14th, 2019, that was the date that we, the defense, requested any and all relevant information related to Will Little's phone. We requested the phone itself. or access to the phone itself. We requested any extraction reports. We requested any information attendant to that phone. On February 22nd, 2019, the Commonwealth, through their representative, falsely denied having any access to the information on the phone and to the phone itself. That was a clear and intentional false misrepresentation and falsehood that was designed to keep us from knowing exactly what the Commonwealth had in their possession. It is inexcusable. The Commonwealth has taken the position, and they're parsing words and trying to be, I think, too cute by half. They're now taking the position, well, hang on a second. What Mr. Giordino was responding to was his physical access to the phone, not the information surrounding the phone. He said he didn't have the phone, which was true. He didn't say he didn't have the information to the phone. That's not what he was requesting. Well, the Commonwealth knew exactly what we were asking for. We weren't parsing words. We said we need access to the phone and the information on the phone. Why? Because we think that it contains potentially at that point, and now we know it's true, exculpatory evidence. So to parse words between were you actually asking for the physical phone or were you asking for the information attendant to the phone, that is a non-starter. And it's a little bit of a desperate attempt on the Commonwealth's part to cover their tracks, as it were. But in point of fact, he's even wrong about that. Mr. Glennie, in his moving papers, which I just received this morning, indicated, well, what Mr. Giordino said was, we don't have access to the phone. He wasn't talking about the information on the phone. So now let's parse those words out and talk about something else. This is our actual request. Number one, in a January 14 letter, 2019, we request the following information. Number one, the cell phone numbers, carrier information, passcodes, authorized users on the accounts associated with any cell phones used by William Little between July 7th, 2016 and present. Thereafter, there was a meet and confer on February 27th, 2019. So about about a month and a half, 6 weeks after this letter was sent, there was a meet and confer by Miss Elizabeth Little, my associate in my firm, and Mr. Giordino. That was a telephonic conversation. Miss Little took contemporaneous notes. I'm holding those notes. Number one, in response to that request, Mr. Giordino's response, quote, investigator does not have this information, not in the care, custody, or control of the government. That was a blatant falsehood. They knew they had it. They had had it for a year and a half. They took the phone on November 29th, 2017, and they didn't give it back until December 18th, 2017, during which time they did apparently a full forensic download, I expect that they're going to say, and they did a forensic extraction report. And all of that was hidden from us from January 14th until basically present. On April 4th, if the court remembers, we were back in court in front of this bench on April 4th, 2019. At that time, the court was going to rule on whether or not we got access to William Little's phone. You'll recall that.
Mr. Giordino indicated he had some of the information you were looking for. He was going through it, right?
And on that date, I was sitting in that bench right there, the first row. Mr. Giordino was standing just inside the bar. After having received the partial report that he gave us, I had flipped through the first 4 or 5 pages, and I looked up at Mr. Giordino and I said, Mike, I'm troubled by this. Why is it that we're just now finding this out? You've had this information for apparently a year and a half. And his answer to me was, my apologies. I owe you an apology. But there were people in my office who believed that it was better if you didn't know that we had the phone until I've had a complete opportunity to go through it. That is absolutely outrageous, and it should never, ever happen in a court of law. He told an officer of the court, me, something that he knew to be completely false, i.e., we don't have that information, we don't have the phone, we don't have access to it. And Judge, just to bring this full circle, that representation was the foundation on which we, the defense, ended up filing motion after motion, litigating issues in front of this court, wasting the court's time, wasting our time, wasting my client's time, my client's money. This was a concerted effort to keep information from us that is unjustifiable. With regard to the information, if Mr. Glennie's position is, well, he never said he didn't have the information, there is a report that we finally got after April 4th? April 4th. After April 4th, we got finally in the tranche of information that we got was a consent form. Remember, the request that we had made.
Consent form signed by
Heather Unruh.
Ms. Unruh, yeah.
As it relates to Will Little's phone. Remember, just to remind the court, what we asked for was cell phone numbers, carrier information, passcodes, authorized users, etc. This document shows that as of November 29th, Heather Unruh provided all of that information. There's an EMI code.
2917.
Yes.
2917.
That's right. November 29, 2017, they had in their possession this consent form, which has Heather Unruh's name on it. It has Trooper Donovan's name on it. It has the EMI code for the phone. It has the user information, Will Little, Heather Unruh. It's got the passcode, which I won't name in court. It's got a consent, a signature via Heather Unruh, and a date of November 29th, 2017. So the Commonwealth doesn't get to parse these issues out and be too cute by half by saying, well, we said we didn't have the phone. We never said we didn't have the phone. What we said was we didn't have the information, or vice versa. They had both. They had access to both. We then get a new report this morning, which is, I thought I couldn't be more troubled by the conduct of the Commonwealth to date until I was handed this report 20 minutes ago.
Was this part of Mr. Glenny's filing?
This is by Mr. Glenny. No, I don't believe it's part of a filing. I believe Mr. Glenny just very kindly handed me the report this morning, indicating that it had just been done. Trooper Donovan was asked, I guess, by Mr. Glenny or Mr. Giordino or somebody in the Commonwealth to synopsize his recovery of and possession of the phone, because that's the big issue in front of the court. In that synopsis, which is only about 3 sentences long, for the first time ever, Trooper Donovan reveals the following, and I quote, "On Wednesday, November 29th, 2017, Sergeant Scott Brightman and I went to blank address. I believe that's a home address. I will not name it out loud. To meet Heather Unruh in order to gain written consent to access William Little's phone. Heather signed the consent form for an iPhone 5 model blank with an MEI code of blank. Heather said Will had a new phone, but the phone she was giving us was the iPhone Will had in his possession July 7th to July 8th, 2016, while working at the club car on Nantucket. And here's the revelation. Quote, Heather informed investigators she had gone through the phone to remove anything related to what she described as Will's frat boy activities. Are you kidding? Heather Unruh took it upon herself to physically remove exculpatory information from the phone before she handed it to the government. And the government never told us that that had happened, nor did they take the very normal step that you would expect the agency to take, the police agency to take, which is to do a full extraction and recover those deleted texts. Why is Heather Unruh the holder of the keys? Why does she get to be the gatekeeper of information that is propounded to the government or, more importantly, to us? She isn't, and she can't be. It's completely inappropriate.
Can I just stop you for a sec?
Yes.
You indicate that the Commonwealth and the Commonwealth admits that it did an extraction. So when you have if you don't have it, you will have it soon. The benefit of that extraction, per my order and per agreement, with that information, can your expert resurrect those deleted items? Or?
No, that's the second point that I want to, that's a great segue. That's the second point that I want to address to the court. And I will explain right now why that can't be done with, let me see the CD. What I got today was what Mr. Glenny described as, he didn't actually describe it as an extraction report. He said very candidly and honestly, he said, I'm not sure what this is. I'm holding what appears to be a DVD. It has a item number or a DR number of 2017-102-483. I can tell you from my experience, and I'm not a tech guy either, but this is not my first rodeo. This is not a mirror image forensic copy of a cell phone. That usually is terabytes in size, and it usually requires a hard drive, a physical hard drive to put a phone on. This phone that I have, which is an iPhone 10 or an iPhone X, whatever you call it, probably would take up the better part of a multi-gigabyte, multi-hundred gigabyte hard drive. This, I'm guessing, Judge, is the extraction report from which they gleaned. Sorry, reverse that. It's the extraction report from the mirror image. We don't have a mirror image. And I will tell the court now, and I'll explain in some detail so the court understands why I'm troubled by what they do have. I need the actual phone. Their mirror image is not going to be good enough because their extraction report should be a mirror of their mirror image, if you will. It should be an exact copy of their copy. Here's why it's not. We know that Will Little deleted, he or apparently his mother, which was a place I never thought that we'd end up going, but he and or his mother deleted and manipulated the exculpatory texts that were on the phone. 100%. It's not a question anymore. It's absolutely clear evidence. The problem culminates in two issues. There were text messages that were between Will Little and his girlfriend at the time. We've designated her as MD. The DA had those text messages in their possession in the form of screenshots. When Will Little first went to the police, he provided them not mirror images, nothing like that, nothing techie. He just took screenshots of text conversations to support his argument that he was a victim of a crime. And he provided those screenshots to the police officer, to Trooper Donovan. I'm sorry, to State Police Officer
Kelly.
Not Donovan. That original set of reports was to Kelly. Kelly took those reports, and that was the foundation on which these charges were filed. The problem is those screenshots specifically had information missing. There were one-sided conversations, not the concomitant other side of the responses to those conversations. They never sought to find those. Then the DA also had in their possession, since November of 2017, a forensic report from their download, or November or December of 2017, the forensic download. All right, so now that's the extraction report. They've got the screenshots, they've got the report. Here's the problem. Those two items don't match up. As a matter of fact, there's clear evidence that there were deletions by Will Little from the time he gave the screenshots over until the time Heather Unruh handed the phone over. Something was manipulated. We now know, because of this report supplied today, that at least Heather Unruh, at worst Heather Unruh and Will Little, both went through the phone and they cleansed it. They deleted information that they didn't want the police to have. They deleted information that they didn't want us to have. Here's an example, just a quick example for the court. At 1:41 a.m., there was a text, according to the forensic report, MD sent. And it says, quote, Will, leave and go home. Just those 4 words. The response was, should I actually? Question mark. Then the word help. Then the word picture. Clearly, that was an indicator that he was questioning should he even leave the club at 1:41 in the morning. And he wanted to get a picture. With who? With my client. When he handed the phone over to the police, he deleted the entire message except for the word help. Their extraction report only shows help. That's the kind of cleansing that Will Little and Heather Unruh were undertaking when they turned this information over to the police. And what troubles me, Your Honor, it'd be one thing if all of us were fooled by the Unruh family. The Commonwealth wasn't fooled. They had all this information. And they had it when we started asking for the phone. And this is the reason we were asking for the phone, because we suspected that there was this type of manipulation going on.
When you say that they had it when you asked for the phone, they had already done their extraction. The phone had been returned. So the information they had at the beginning of this case, you now have. So, right?
Correct. But that's when Mr. Giardino said, we don't have any information on the phone.
No, I get that, but it wasn't as if there was other information that they had that they hadn't produced.
Nope.
They have everything that they have now. You have. I appreciate that it may not give you the opportunity to bring back these deleted items on the phone.
That's what we're asking.
I get it.
And what's bothersome, Judge, just so I can put a fine point on this, is I'm standing before this court on June 3rd, 2019, making these arguments and these revelations, and I'm sure to the court, you're thinking, my Lord, this is big, bold, new news. It's new to us. It's new to the court. The problem is it's not new to them. They've known since day one what was happening, and they kept it from us, and that is unjustifiable, and it's outrageous. I've never seen a government agency protect information and hold back information the way that it's been held back in this case. I'll do you one better. When we were given the original information, they gave us the screenshots, which we now know they knew to be completely manipulated. And they gave us those screenshots and held back the forensic report, claiming they didn't have anything more to give us. And let us go through this charade of making a motion and coming before the court and flying out here and pounding our fist and saying we need the phone. And they actually objected to us getting the phone on privacy rights. The court remembers this. It's outrageous. How could they conceivably do that knowing what they knew?
You get the phone. If you get the phone, I know you listed an expert who could do the forensic download. Are you sure that if you get the phone, you'll be able to, as I say, resurrect these deleted portions? And does that require passwords for the cloud and all of the rest, or is that?
Well, we've got a password for the phone. The pointed answer to the court's question, which is a great query, is I hope so. Oftentimes, and it's science, but it's not perfection. Many times, if the phone has not been utilized, I'll give a 10-word explanation of how a cache system works on a phone as I understand it.
Maybe your expert can file an affidavit in support of that. If you could do it, that would be helpful.
Happy to do that, yes. The way a cache system works is if you and I text back and forth and we subsequently delete that, that the deleted text goes into a cache system, which is a memory system inaccessible to the user on the phone. It sits there in that cache system unless and until something overwrites it. The way that it's overwritten is if, let's say, I download a bunch of music or videos or photographs, things that are massive in size, megabytes potentially in size, that can begin to overwrite the cache system. Those texts are deleted and gone forever. If that hasn't happened and they're still sitting in the cache, they can be recovered. We expect that's the case, and I was buoyed. I had some good news today, which is in this report. It suggests that at the time Heather Unruh provided the phone to the government, Will Little was no longer using it. He had a new phone, so there's absolutely no reason why that phone shouldn't be in the exact position that it was in 2017, and probably we're going to be able to get those, most, if not all, of those recovered texts. But I'll happily provide a more detailed explanation from someone who knows a lot more than I do in an affidavit to the court.
We do that.
I believe that this court should and must reconsider our request for Heather Unruh's phone and allow us to do an extraction or a mirror image of her phone as well to determine if there's exculpatory evidence, which we believe exists on her phone, still available.
Just, and to that point, over what period of time would you be looking to perform an extraction?
Well, it would start at July 7th, 2016, and probably go through the filing of the case in late 2018, December 2018, which is consistent with the time parameters that we've asked for Will Little's phone. Like, we're entitled to both. Just to let the court know, Mr. Glennie told me this morning that his position on the Trudeau communications is that we have everything. There are no other communications that are responsive to our request. If that is the Commonwealth's position, I would expect them to put that on the record as an officer of the court to state that. I'm deeply troubled by what has been happening and certain misrepresentations that have happened up to this point. But I'm going to stand above that, and I'm going to trust that anything that Mr. Glennie says about Mr. Trudeau's communications, it's true. It better be true. I can say that.
Well, I'm glad to know that there has been that communication, and my review of your pleadings and likewise Glennie's pleadings indicate that the Trudeau met with his sister in mid-March.
That's right.
He was fully underway at that point. So, I mean, it would be hard to, and Trudeau properly revealed that communication to the DA as he should. So it would be hard for the court to find that there was any bias in terms of our motivation to bring this case based on some communication that Trudeau had with his sister.
And certainly,
well after the fact. Go ahead.
And certainly, if we get Miss Unruh's phone, which I'm hoping that we will, if there are communications going from her to Mr. Trudeau, it'll be revealed on that phone. So we'll see. But in the meantime, I take Mr. Glennie at his word. If there's no other communications, then I will table that issue and submit on that issue.
Thank you.
Thank you. First Assistant District Attorney on behalf of the Commonwealth. With respect to that aspect concerning Mr. Trudeau and his sister, the court should be aware, I'm sure that it's probably just a statement, that there's no relationship between anybody in our office and Ms. Unruh. The alleged relationship is with the sister of somebody in the office and Ms. Unruh. So, and I would also state for the record, in the pleadings that I handed in today, I state again, that is the extent of what we have, which I've also attached to my pleadings today, concerning the issue of communications between Mr. Trudeau and his sister, or Mr. Trudeau and members in our office concerning that conversation he had in Miami, I believe it was on St. Patrick's Day, 2017. First of all, I'd like to suggest, what are we here for today? We're here for a motion that was filed by the defendant that was entitled Order to Compel Discovery Pursuant to Mass Rule Criminal Procedure 14 in Brady versus Maryland. And there are two things that were being sought in that motion. One is the phone information, and the second one was information concerning Mr. Trudeau. With respect to the phone information, if there's anything that can be gleaned from what we provided to the defendant today, that could certainly be subject to a motion subsequent to this. There's been no formal discovery motions filed in this case. Discovery's ongoing. The case is ongoing. There's been no conference report filed that says that discovery is complete or that we have any discovery at this point. Furthermore, before the court issued its order, which I think we all understand the parties were not aware of until I think it was the 31st, negotiations were conducted between Mr. Giardino and the defense counsels, I believe mostly with Ms. Little, concerning the turning over of what I call the forensic download. And that may not be the correct term to be using.
Would you call it the forensic what?
Download.
Oh, download.
And again, if that's not the correct term, I think we all know what I'm talking about. It's what's contained on that disk. We were under the impression that all that needed to be done was have that protective order signed. And if that had been done prior to today's date, that disk would have been provided before today. So the Commonwealth was willing to turn that over. Now, what led up to the point of us turning over more information, although not known at the time, but then the court has ordered the Commonwealth to turn over because the court's order is less than what we're willing to turn over. What happened is that Mr. Giardino, before the court on April 4th, indicated that he was going through that forensic download, for the term I'm using, to see if there's anything that might need the court's intervention, if there was going to have to be some interaction by the court before that was turned over. The court was aware of that. Mr. Spacey's attorneys were aware of that. And then the court even asked Mr. Giardino, how much time do you think you need? He said, I think I can have it done by June. I don't believe there was an objection at that time made by the defense. The court didn't say that that was an unreasonable amount of time. He finished before June. He agreed that the Commonwealth should turn over the entirety of what we had in our possession. And that was done. That was done today. So what is it that the defendant is asking the court to order here when we've already turned it over and we're already willing to turn it over before this motion was even filed, known to the defendant? The second aspect of the motion was for the information concerning Mr. Trudeau in the conversations with his sister. The defendant was in possession of the answer to that to an informal request for discovery again. In fact, that informal request, which is as an exhibit in my submission, had, I believe, 4 different things that they were asking. 3 of them were very specific, and one of them was not. The ones that were very specific were answered very specifically.
I saw that.
Given the information that was requested. The one that was a little more, I would say, overly broad, and the Commonwealth had some reservations about. The Commonwealth stated that. We have some reservations about this. The wording speaks for itself. It's in the submissions. But irrespective of that, here's what our answer is going to be. Now, if the defendant's not satisfied with that answer, that's when the court could become involved at a hearing. So I would suggest that they had that information as well before this motion was filed. Everything else I would suggest, Your Honor, has to do with perhaps motions that may be filed down the line that were relevant to what this information is here. Now, I certainly understand that there was a report that was given today, and I can understand defense counsels wanted to bring up this unused phone, but that's fine. With respect to that, I believe that they would still have a right to appear and indicate whether they have any objections or whatever concerning that if the court were to deem that to be reopened. The suggestions that Mr. Giardino had made some statements, Your Honor. And now this, I would suggest, really has nothing to do with what the motion was filed for. The motion has been answered in the sense they already have the phone information. They already have the information concerning Mr. Trudeau's sisters, that conversation that took place. So the rest that's in the motion, I suggest, it's just fodder for another day. Not for today. Not for this. If they want more specific answers, they haven't even looked at what was provided to them today, yet they're telling us what's on there or what's not on there. I think they need to look at that. If there's information that they feel we have that has been provided, they could ask for that specifically, and we can answer it. Either we have it or we don't.
I didn't get not of the opinion that they think you still possess information that they want. My understanding is that what has been provided, and you're right, they haven't looked at it yet, but it appears to Mr. Jackson that it's not going to contain all of what he needs, which he could obtain perhaps if he had the physical, the phone. So I don't think there's any indication that you're still holding on to anything with respect to the phone. It's just that what's been produced isn't going to be enough for him to sort through and get the deleted text. So
and that could be, again, fodder for another day. If there's a motion to suppress, a motion to dismiss, because
he's making a motion to get the phone, which he requested early on, and I, in a rather conservative approach, said let's give him the extraction and see what happens from there. Go ahead, sir.
we don't have the phone.
No, I know. And now, I understand that. I see today that you don't have it. If that was revealed earlier, I wasn't aware of it, but I did see it in your pleadings.
But all I was suggesting that the motion that was filed, Your Honor, was answered, and all the information could have been provided had that protective order been signed and given to us prior to this date, before even being here today. And the rest of the information that's contained within that motion, Your Honor, I suggest was just an attempt to get their version of the case out before the media, which it certainly did do, as you can see by the attachments that I put in considering the media attention to this. So the position of the Commonwealth is that there was no affirmative misrepresentation made by Mr. Giardino. If there were some misunderstandings between the parties, we certainly apologize for that. But we are attempting and have attempted from the beginning. If there's an issue, let's address it. If we need the court's available. That's what judges are for. If it's something we can agree to, let's agree to it. If we disagree on what we provided, we can take that to another step. The Commonwealth suggests, Your Honor, that this motion, number one, is not timely in that they have the information that they're requesting, and that the other things that they're asking for will be subject to another motion at a different time. With the understanding, I understand that that report was handed today, and that brings up issues concerning this unused fund. But everything else I would suggest, Your Honor, is already been taken care of. So I would ask the court to deny the motion for the reasons set out in the memorandum.
Thanks.
If I got caught like the Commonwealth got caught, I'd say it was miscommunication too. The best I can do. but it's absolutely not true. Mr. Glennie knows it. Mr. Giordino absolutely knows it. It was not a miscommunication. We were clear as a bell. We don't suffer from inarticulation. We told Mr. Giordino exactly what we wanted. We wanted information on the phone. We wanted everything that they had about the phone, and we wanted the phone itself. And his comment to us, it is not in our care, custody, and control. There's no other way to parse that. And I don't make these points lightly. It is not fun for me. This is not enjoyment for me. I don't like having to discuss an active misrepresentation by the people, by the Commonwealth on behalf of the government. I think it's outrageous. I think it's unjustified, and it's not fun. But it's also inherently not fair to us. And so Mr. Glennie's comments, he's doing the best he can to call it a miscommunication. There was no miscommunication. This was an active misrepresentation, and it should never, ever be tolerated, ever, especially on behalf of the government.
But what your motion boils down to at this point is that the Trudeau issue is off the table. What you're looking for is the phone.
Correct.
That's what this all boils down to, is you want the phone.
And at this point, given what we now know, and by the way, Mr. Glennie also says, well, they've got what they wanted. They've got this forensic extraction. They've got what they wanted. That's not true. Number one, we already know, and Mr. Glennie already knows, and he should be concerned that his extraction report is inaccurate. It is not an accurate representation of what's on that phone. How do we know that? Because of the group texts. There were group texts that they have in their file that don't exist in the extraction report. He knows that. I know that. So now we can all agree. Let's stop dancing around. We can all agree the extraction report is inaccurate. It has been manipulated. There have been deletions on it. Not by the government. That's not an accusation that we're making, but certainly by Heather Unruh or Will Little or both. So we need two things, Your Honor. I want the actual forensic download, which is not the extraction report from the download, but the actual forensic download. Colloquially, it's called a mirror image. I want the mirror image that Mr. Glennie and Mr. Giordino have currently in their possession. They do have that. Either them or at their crime lab, they've got it. Number two, the second thing I want is the actual phone. I'm entitled to go to the source data to find out what was or was not deleted. And that's what we're seeking. Those two things as it relates to the phone. The third thing is I want the same information as it pertains to Heather Unruh's phone. Now, I don't have a good faith belief that they've ever done an extraction of Heather Unruh's phone. So I don't think that exists or that they have it. So I would ask for her phone, for my expert to be able to do that forensic download or mirror image so that we can then pull an accurate extraction report from that phone as well. That's what we're asking for. That's what we're entitled to.
Respect to that request, as Glennie indicated, I denied that request initially, and I know you want me to reconsider it.
I understand.
I'll take another look at it. If I decide that there's enough to pursue it, there would have to be a further hearing. They would have a chance to come in and argue against it. So
that's fine. We accept that.
I understand. Okay, just so we're clear about it.
I'm not trying to sort of overstep process. I get there's a process.
Yeah, I'm all right. Fine. Thank you.
The last thing that I'll suggest to the court is as to the issue of timing. I brought this up at the last hearing. I'd like to address it again.
Sure.
Mr. Spacey is entitled to his speedy trial. Period and amen. What he is suffering every day that this goes on, every single day. There are cameras in the courtroom today. There are reporters populating the courthouse. Every day that this goes on without resolution is a day that he suffers. That's a day that he's not getting justice. That's a day that he's not getting his due process. The shenanigans that have been going on the government side are outrageous. They're unjustified. They're inexcusable. And we shouldn't have to suffer the ills of having to come back over and over and over. And every time we come back, we get something new and revelatory. There's a new revelation every single time we come back to this courthouse. That is not fair. That's not how the government should be conducting its investigation. That's not how it should be preparing for trial. If they weren't ready to go to trial on the day they filed this case, they shouldn't have filed it. And I submit they absolutely shouldn't have. This is a ridiculous case, and they shouldn't have filed it to begin with. But they did it. They unlocked that barn door, and now the horse is out, and they've got to go to trial. We're entitled to that. More importantly, Mr. Spacey's entitled to that. One of the things that I found it'd be amusing if it weren't so sad. In response to the motion that we filed, Michael O'Keefe, the DA, the sitting DA for the Cape and Islands DA's office, was confronted by a reporter who said, what do you think about these accusations and the allegations concerning your office and misrepresentations that your office had made? His response was, if Mr. Spacey was not who he is, no one would care about this case. I know I learned a term in law school, gobsmacked. I was taken aback by that statement. That was ridiculous for the sitting district attorney of this county to say if he wasn't who he said, if he wasn't who he is, nobody would care about this. What is he saying? What's the translation? If it wasn't Mr. Spacey, he never would have filed the case. Is that the translation? Or is the translation, if it weren't Mr. Spacey, nobody would know about these representations. Nobody would know about holding back evidence because nobody would litigate this to the extent that we are. If they're not ready to go to trial, they shouldn't have filed the case. And if they think nobody cares about this case, my response would be to the Commonwealth, I'll tell you who cares about this case. We care about this case. Mr. Fowler, Mr. Spacey cares about this case. The people of Nantucket, they care about this case. If they don't care about it, so be it. God bless them. But we do, and we want a trial. And we're ready to go to trial. If this court were to grant us an expeditious discovery order today or in the coming week, I promise you, Judge, we will act expeditiously, equally expeditiously, to get ready. No matter what that information is that comes to us, we just need the time to download it, analyze it, and then we're ready for trial. And we don't want to wait till October or November. We think we're entitled to a trial within 8 weeks or so.
Won't happen.
Why won't it happen, Judge?
The way things work here, and I appreciate that you're unfamiliar with them, is we have jury trials here every other month. And that's why I'm here this week. We'll have jury trials this week. The next trial session will be in August. There is a trial assignment date that occurs before that. And at that point, I set up the trials for that particular week.
Okay.
So again, this week, August, October, December. This case, I would expect, is not going to be able to be tried in one of the normally assigned jury weeks. I'm going to have to find separate space on the calendar to accommodate this case because, as you indicated that.
Sorry, Judge.
It's all right. You indicated that you thought it was going to carry on for 2 weeks. Maybe it will be because of the celebrity that attaches to it and the difficulties in selecting a jury. Maybe. I don't know. But the actual trial of these cases, similar such cases will take, maybe 2 days, maybe 3 days. It's not that complicated, at least from the court's perspective at this point.
I agree.
But in any event, I need to find, there are several other courts that use this space, the probate court, the superior court, the juvenile court, et cetera. So I need to be able to carve out that piece of time, and we're going to need to bring in more jurors than is normal. So if you're lucky, and I'm not being flip, if we're lucky, because I want to get the case tried too. I appreciate that it's a burden on him, but then again, every other defendant, and if you get in the queue, there are many ahead of you. It's likewise a burden to them, and some are in custody to have their case tried. So. I'm disinclined to let Mr. Fowler step in front of those people, except that there are considerations that need to be addressed in terms of a separate week.
And that's what I would ask. If the court could accommodate us in August, even late August.
No, it can't. First of all, to try this case, it's difficult enough to get accommodations on this island anytime in June, July, and August. It would be it would be impossible. Not next to impossible. It would be impossible to get this case tried.
I'll stay in a tent.
Well, I'm glad to know that. But
get accommodations are lax, but we'll make do, Judge.
I appreciate it. But we have the issue of the jurors. As I say, we need to be able to summons them. That requires at least 90 days, et cetera. So it's just not an easy thing to accommodate. And as I say, Mr. Fowler, as much as I'd like to get his case tried for a variety of reasons, among them so that we can all move on to the next case, whatever, he's still one of the individuals who is in the queue. And I'll do the best I can, as I'm sure the Commonwealth will, to move this case along. It's not happening in August. Whether it can happen in October, November remains to be seen. But that's what you're looking at.
My co-counsel reminds me that, and I just want to bring this to the court's attention. I don't want to, the horses, if it's not dead, it's on its last leg, and I don't want to beat it. But the court did indicate at our last, and this is new procedure to me, the court indicated at our last hearing that there's a possibility the court might have, which is to set aside a special panel that's sort of outside the bracketed timeframes that the court might accommodate. If the court can at least consider that.
But even if, and I am going to do that because I'm not going to interrupt, do the best I can not to interrupt, the flow of cases on this island. So I'm going to have to pick a separate space of time. But that still requires that we bring in jurors. That can't happen overnight. And so again, consider that the horse dead with respect to a trial in August. So
I was hoping you weren't going to say that.
Sorry.
All right, Judge. I appreciate you at least listening.
Sure.
Thank you. Submitted.
All right. Anything else, folks, from anybody, Mr. Glenning?
No,
I
sir.
feel I need to address a couple of things. One is really kind of a housekeeping matter. I'm sure this wasn't intentional, but there was a mention made of the officer Kelly, and he was referred to as a state police trooper. Now, he's not.
He's not.
Talked about.
That's my mistake.
Right.
Thank you.
And then, I would suggest that the Commonwealth, as I stated in the opposition, categorically denies that there's any affirmative, conscious misrepresentation at any time made by ADA GRD.
Understand.
And then secondly, Your Honor, there was some suggestion concerning about the media quote by Mr. O'Keefe. Now, I've had an opportunity to speak to him actually about that, and he was talking about the media, that the media wouldn't care if this was anybody else besides Mr. Spacey. Not that the people of the parties wouldn't care, but the media. And I think the court has seen that this is not the typical case in terms of the media interest. Not that there's anything wrong with the media being interested, but they are interested, and they're here hanging on every word. And I addressed the media in my submission, and I would just ask that you, take a close look at that. Thank you.
Thanks, gentlemen, lady. I appreciate it. I did indicate in my ruling that we could perhaps have a further pretrial if we were going to have one via video conference, if that would be helpful, I'm sure, to you, as long as we could orchestrate it. I would like an affidavit from your expert, if you
We'll
can
take
do
care of
that as quickly as possible. That would be helpful. And do you want to pick a further date at this point?
Your Honor, Monday the 8th seems to work with all of our calendars if it works with the court's calendar.
The 8th of July?
Yes, Your Honor.
Sure. Okay. Let's put it on for that date. All right, folks. Thank you very much for your appearance here today and your arguments. I'll take it under advisement and hopefully can, as I say, issue a ruling later on this week. But I do want to see that affidavit.
We'll get it to you by the close of business tomorrow.
I appreciate it. All right, folks. Thanks again. All right. Thanks. All right, gentlemen, this is scheduled for a hearing pursuant to the Rule 17 summonses that the court sent out. Mr. Garabedian, I presume that the phone has not been located. Is that right, sir?
Your Honor, if I may interject
Sure.
for 2 seconds, before Mr. Garabedian goes into the details of the data collection of the phone, there are witnesses in the courtroom that I think should be excluded. Given the fact that we're going to be talking about some of the details, I believe each one of them are fact witnesses that will have information specific to what Mr. Garabedian is about to specify to the court. I think it's more appropriate if they wait outside until and unless they're called to give their particular facts.
I have no problem. Do we know who those witnesses are?
I do. Heather
Okay.
Rubin, Will Little, and Nick Little.
Are they here? Yes.
They're seated
All
in
right.
the front row.
Okay, folks, I'm going to ask that you step outside if you would. We'll call you in when your testimony is needed. Thank you.
And Judge, I hate to interject, but could we just make sure when Mr. Gary Beating is speaking that he's speaking near a microphone
Sure.
so that we're ensured that it is recorded?
Yeah.
Thank you.
That one.
Not here because of my hearing, Your Honor. Sometimes,
We'll stand.
Your Honor, we could not locate the phone. Historically, let me just say this. There was a civil suit filed because of the emotional roller coaster my client, Will Little, is on. The civil suit was dismissed. I just want to put this into
I
context.
understand.
Now, he only wanted one roller coaster ride at a time. Criminal cases, no. We could not locate the phone. My clients do not recall ever receiving the phone. And when I say my clients, I mean Will Little, Heather Unruh, and Nick Little. It is my understanding the government has a forensic image of Will Little's phone, the original phone.
Which they turned over. Yes.
Yes,
Right.
and which has more information than I have on who I've been able to retrieve.
You know what I want to know? Miss Unruh turned the phone over to you folks, and you gave her a receipt for the phone when you received it. At some point, the phone was turned back over to somebody because you indicate you no longer possess it.
That's correct.
I would think that protocol would dictate that when you turn that phone back over to somebody, you get a receipt from that person saying, "Okay, we have the phone. Thank you very much."
I would not agree with that.
You don't agree that that's the protocol, or you just don't have a receipt?
No, I don't agree that that is the protocol.
Okay, well, you know what the protocol is. It would seem that would be the logical thing to do. Can you tell me? You don't. So you're indicating you don't have a receipt when the phone was turned back over to somebody. Is that right, sir?
That is correct.
Okay. But do you have some documentation in your file, in the DA's file, that indicates to whom the phone was turned over and when?
What happened was there was a report that was generated concerning turning the phone over to the Trooper Donovan is here today.
Yep.
We requested to produce him. He's here. And the phone was obtained by the Commonwealth on Wednesday, November 29th. It was then turned over and again, I apologize if I used the wrong terms, but for the forensic download, the information we provided to the defendant on December 14th, that was done on the 15th, and it was returned to the Littles by Trooper Donovan on December 18th. That's putting the phone in the possession of the Commonwealth for approximately 20 days. Trooper Donovan remembers turning the phone over to either Will Little, well, it wasn't Will Little, it was either Will Little 2 or Will Little 3, either the father or William Little, the complaining witness in the case.
Sure.
And that would have been, as I said, on Monday, December 18th, 2017.
If the phone was returned, it was given not to the complainant. The complainant is fine.
Like, I mean, that would be the logical starting point. Who got the phone and when? It appears the date is set 12/18/17, but nobody knows to whom the phone was given. There's no documentation, although you indicated you saw something. It was something.
If I may, I think he's referring to the police report that I was talking about. There's no receipt or anything. There was a police report that was generated by Trooper Donovan, and I'm sure that must be what he's referring to.
And did that report name someone who received the phone?
I don't believe it did.
Yes, it did. Yes, it did.
I'm going to give everybody a chance to speak so we can.
Let me fill this out just a little bit.
Sure.
Trooper Donovan did, in fact, write a report. Where's Trooper Donovan? We've met, and I don't.
I'm sorry?
In the court. Is Trooper Donovan in the court?
No, he's here. He's in the back.
He's not in the courtroom. Okay, I just didn't want to be rude and not acknowledge him because I've met him and I didn't recognize him here in the courtroom. Trooper Donovan did, in fact, write a report about having returned the phone to Nick Little. He specifically said to Nick Little.
But they're both named Nick.
Father is the son.
All right.
He said, well, actually, in his report, he said Nick Little or Will Little. He's not sure which of the two. They were both home at the time, and he remembers it because that's the date that he interviewed Kyla, the daughter. However, this report that I'm referring to was generated June 10th, 2019. This is 2 years after the fact. The court instinctively went to the point, what is the protocol for the government to maintain a chain of custody for an item of evidence that you're either receiving from or returning to an individual? Of course, there's a protocol that should be in place. If there's not one, there should be. And if there's not one, we end up in a disaster like this because nobody knows what happened. The UNRUs are saying the government still has it.
Interrupt, but he interrupted me, indicating that when I said it was returned to one of the two Littles, that was incorrect, that there was a named Little that it was returned to. And I think he just said that it wasn't a named Little it was returned to.
It was
one of the two.
Will.
I got it.
And that's what I said.
Those are two names.
So I don't understand what he's talking about now. There's no question before him.
Gents, I got it. You're both going to have a chance to address me fully, and then we'll put the witnesses on that.
Absolutely.
That hopefully will clarify some of the.
Absolutely. If I can just finish this point.
Go ahead.
There is, according to the government's discovery, their disclosure to us, there is no receipt that is concomitant to this particular report that suggests that Nick Little or Will Little ever received the phone. The government can't point to any documentation that follows or tracks the location of that phone. And now that it's missing, it's on them. The UNRUs are saying the government never gave it to us back, or at least we don't remember ever getting it back from them. The clear suggestion being they still have it. The government's saying, of course we returned it. No, they're pointing fingers at each other and there's no receipt or documentation. And guess who loses because of this? That would be us, because we're entitled to the phone. And I appreciate Mr. Garabedian's efforts to maintain or obtain a forensic download of a MacBook, another phone, a second generation phone, a third generation or a fourth generation. None of that answers the central question, which is where is the actual phone? That's what we want, and we still don't have it.
Well, so what may flow from that is that if the phone is not produced and it's beginning to look like it will not show up, well, there are consequences.
Yes.
That could. I'm not suggesting they will, but they could, depending upon whether the Commonwealth had a duty and it was breached, or whether something else occurred. Again, I'm not making a decision that I wouldn't be surprised that after we hear from everybody that there's a motion filed requesting sanctions, and then we'll see what happens from there. So I'm inclined to actually, I think I bring the trooper up first because he can tell us whatever he can tell us about the phone being returned, but I don't want to cut off your opportunity, Mr. Glennie, to address me further. Certainly you can address me after we've heard from everybody, but is there anything more you want to say, sir, before we bring up?
No.
The questions will be restricted to the whereabouts of the phone and the condition of the phone. All right. So the questions will be limited. And however, the condition of the what if anything might have been deleted. And the reason I say that is because if the court finds and if sanctions are requested, part of what the court needs to consider is whether or not this was an important piece of evidence that now is missing, and what if any sanctions should flow from that. Again, I'm not telling you that I'm going down this road, but this is relevant information. I don't want to bring everybody back here to have a further hearing. I want to deal with it today. Anything further, folks, before we bring the trooper in? So I'm going to allow, obviously, Jackson, I'm going to allow you to go first. And Lenny, you may or may not have questions. Obviously, you can talk to these people outside the court, but if you want to ask questions, you can do that. Scarbedian, I appreciate you being here and giving us the information, but with respect to the questioning, that's not something you have any standing to do. But please be seated as we may come back to you on other matters. Can you bring the trooper in, please?
I do.
Good morning, still. All right. Would you identify yourself, please, for the record?
Trooper Gerald Donovan, State Police.
Okay. Jackson, go ahead. Do you want to inquire?
Thank you. Trooper Donovan, thanks for coming and joining us this morning. You're the lead investigator on the case before the court, the Commonwealth versus Fowler, correct?
I was, yes.
And you interviewed William Little for the first time on November 22nd, 2017, correct?
That's correct.
There was a report, at least one report, that suggested that it conducted in 2016. That was a typo in the report. In fact, the first time you ever made contact with William Little was 2017. Is that right?
That's right.
And your understanding is the first time Officer Kelly from the Nantucket Police Department ever made contact with him was also 2017, correct?
That's correct.
All right. In preparation for that meeting, you read Officer Kelly's report. Is that right?
That's right.
They were in the form of screenshots. He sent contemporaneous text messages that he claimed were taken on the night of the incident in the form of a screenshot to Officer Kelly, correct?
Yes.
And you reviewed those before your interview with him, obviously.
I believe I did, yes.
Okay. Made those part of your report, as a matter of fact, didn't you?
Yes.
At some point, you realized that there was data on that phone that was central to your investigation, correct?
I wanted some information from the phone, correct?
Why is that? Why would you want data from the phone?
Because he told me that he had used his phone and that there was information such as the contact of Mr. Spacey, things of that nature. If they were on his phone, I wanted to have it.
And the screenshots would not necessarily be the best evidence of that, correct? It would be the data on the phone.
The phone would be the preference, yes.
In other words, as an investigator, you want to go right to the source, the unadulterated source of the information, if you can, don't you?
I would want the information from the phone. That's correct.
All right. Did you inform Will Little that you wanted information from his phone?
Yes.
Did you have a conversation inform Heather Unruh, Will Little's mother, that you also wanted information from that phone?
Yes.
What about Nick Little, William Little's father? Did you indicate to him that you were interested in data from the phone?
I don't remember speaking with Nick, mostly Will and Heather.
And you made it abundantly clear to both of them that there was data on the phone that you were interested in, you wanted to recover, correct?
I asked them if we could, yes, have consent to look at their phone. That's correct.
Perfect. As a matter of fact, you got a consent form.
I did.
That's the document that I was referencing just a second ago. Recognize that document?
I do. This is a consent form. I'll have people who are cooperating with the police sign in order to access the information on a digital device.
Does it have any names that you recognize on it?
It does.
Does it have your name?
It does.
And it also has Heather Unruh's name, correct?
It does.
What's the date of this document, sir?
The date of the document is November 29th, 2017.
Is that the date that you received from Heather Unruh consent to retrieve her phone and do a document or do a data dump from the phone?
Yes.
Okay, so she obviously had control of the phone at the time?
Yes, they had the phone in their possession.
When they say they, I want to be a little bit more specific. She had the phone in her possession, correct?
That's correct.
When you visited her, Will Little was not there, was he?
He was not.
He did not turn the phone over to you. She did, correct?
Heather Unruh turned the phone over to me.
And she also indicated, I'm sorry, I stepped on your words. Could you repeat that one more time?
Heather Unruh gave me the phone.
And she also indicated when she gave you that phone that she had access to the data on that phone, correct?
She gave me the phone with the data on it.
Okay.
Do I understand your question?
It's an awkward question on my part, and I apologize. If I walk over and grab your phone, I can hand that phone to the judge. If I walk over and grab your phone and I've got the password and can get into the data, and I hand that phone to the judge. In other words, she had access to the data vis-a-vis a password so that she could get into the phone.
That's correct. It's on the consent form.
And she relayed that password to you. You anticipated my question.
Yes.
Okay. So there's no question that on the date in question, November 29th, Heather Unruh not only had sole possession of the phone, but she also had access to the data on that phone.
Yes, by having the password.
And if in
That
fact,
answer your question?
that is my question. And so if in fact, Donovan, she wanted to get into the data, I don't know, send a text message on that phone, she could have done that, correct?
Yes, yes.
Right. And if she wanted to, I
It's
don't
a
know,
little bit more complicated than that, but yes.
but she could get on the phone
Correct.
and use it as her own.
Yes.
And she could delete things from the phone if she wanted to.
If she had access to the phone, she could do whatever she wanted with the phone.
As a matter of fact, Trooper Donovan, she indicated to you at that time that she had in fact altered the data on the phone before she
She said she had deleted some frat boy activities, something along that line.
Did you inform at any point, Trooper Donovan, did you inform Will Little that he should not in any way manipulate, delete anything from the phone that you had, that you were interested in?
No, I never did that.
You never told him, keep the phone in as pristine a condition as possible. Don't go deleting things before you give it to him?
No.
Don't you think that might have been a wise instruction to give Will Little?
Objection.
What? Go ahead.
Causes speculation. You
Well,
didn't do it.
you know what? You can answer it. Go ahead.
I didn't do that. Will Little was cooperating with the state police. I didn't foresee him deleting anything that would be a hindrance to my investigation.
Now, in retrospect, that might have been a smart thing to do. Tell him, don't delete anything, correct?
Sure, there's a lot of things in retrospect that were great.
Did you tell Heather Unruh, don't delete anything from the phone?
I didn't.
Same question about Heather. In retrospect, you think that might have been a wise decision to tell her, don't delete anything from the phone?
Sitting here now, sure.
All right. And in fact, in point of fact, Trooper Donovan, she indicated she did delete certain items, and she described those as, what did you call it? Frat boy activities?
Yes,
Did you ask her why she deleted these quote unquote frat boy activities?
I didn't.
Did you understand, given the fact that she admitted to you having deleted certain data on that phone before she handed it over, that there was data on the phone that she did not want the government to see or have access to?
Yes, my understanding was that she deleted frat boy activities that she didn't want us to see.
And you took her out of court, Trooper Donovan, that it was just, and I'm putting quotation marks around it, just frat boy activities.
I did.
Did you investigate further exactly what the data was that she had altered and deleted?
I looked at the phone, if that answers your question.
It actually doesn't. Did you, if it's deleted, you looking at the phone's not going to do much good, right?
Well, I can see some deleted items, and I can see things that basically weren't deleted that looked like frat boy activities. So my first thought was probably not the best job of deleting things.
Especially if they weren't frat boy activities, but were text messages or otherwise, right?
Well, my answer to the question is in regards to frat boy activities. I did see there are deleted things on the phone, correct?
And those deleted things go beyond just simply frat boy activities, don't they? According to the data extraction report.
Yes.
As a matter of fact, the screenshots that Will Little, those original screenshots that he provided to Officer Kelly, those include some significant deletions, correct? Of the text messages from the night in question.
Which screenshots?
There's 3 sets of screenshots, 3 JPEGs, if you will, that were sent to Officer Kelly. Those are the JPEGs that you reviewed before interviewing Will Little, according to you.
Yes.
Those screenshots themselves include deletions from the night in question. Those text conversations have deletions having been removed according to the forensic data report, correct?
I think there are deletions within the text, yes.
And do you know if it was Will Little or if it was Heather Unruh who performed those deletions and alterations of the data?
I do not know.
Did you ask?
I did not.
A couple of more points, Trooper Donovan, on the issue of the deletions. You did not memorialize in any report at the time, consistent with the recovery of the phone, the fact that Heather Unruh had admitted to you deleting items off of the phone.
Correct.
As a matter of fact, you didn't do that until when?
2 weekends ago?
2 weekends ago from today's date.
I don't remember the date of the report, but I did it recently.
May I approach briefly? Yeah. Take a look at a copy of that document. Tell me if you recognize it.
I do.
How do you recognize that, sir?
This is my report related to my conversation with Heather when I picked up the phone, and the date of the report is June 2nd, 2019.
Great. To refresh your recollection, it was actually June 2nd of this year, a couple weeks ago, that you actually, for the first time, memorialized the fact that Heather Unruh admitted having altered or deleted the phone before handing it to you.
Correct.
Sorry, altered or deleted data from the phone before handing it to you.
Correct.
Would you consider the fact that data was altered or deleted from the phone before you were handed the phone a relevant event in your investigation? Relevant fact in your investigation?
I think ideally I would have liked to have had the phone July 9th, 2016, closer to the event.
Sorry, go ahead.
Within that time frame, anything could happen to the phone. People go through their phones all the time. I think July 9th would have been the best time to have the phone. I get the phone in December. There's so many different things that could happen. I have a mother who's giving me the phone. She wants to delete some frat boy activities. If she had said I deleted things related to this investigation, that would have been a different story.
So you took her at her word?
I did.
Had no reason to believe that she might, I don't know, fib a little to the lead investigator on issues related to her son's phone?
I didn't think that Heather Unruh would be lying to me. So yes, I did take her at her word.
But now you know that there were data on the phone in addition to just frat boy activities, whatever that is. It was deleted, correct?
You can see on the phone that things have been deleted.
So
All
now,
sorts of things.
let me ask you now. You said at that time you didn't think that Heather Underwood would lie to you.
Correct.
You're going to change your opinion now?
No, I don't think she lied to me. I've seen, obviously you can't see what's been deleted if it's completely gone, but you can still see items that have been deleted that remain on the phone. I didn't see anything there that caused concern that would be exculpatory for your client. I just saw things that have been deleted.
How about the text conversation from the night in question
With whom?
with the young lady whose initials are MD?
Okay.
How about those deletions?
Okay, you can see that.
So in fact,
But I don't know who deleted that.
But who are our two choices?
Well, what I was trying to make the point of earlier is that July 9th would have been, excuse me?
That's my question to you. Nothing else.
Okay, it could have been Will or it could have been Heather.
It was either Will Little or Heather Underwood, correct?
I just said that, yes.
May I have just a moment, Your Honor? So you want to bless me?
No, I'm okay. Thanks, Your Honor.
There's another set of data, Trooper Donovan, that I'd like to ask you very briefly about. We've talked about the conversation between MD and Will Little. There's another set of data that was text messaged, it was screenshot over to Officer Kelly. It included what I refer to as a group text. I don't know how else to describe it. You know what I'm talking about?
I do.
And you obviously reviewed the forensic data report as well.
I did.
So the data report is from I don't have my phone, but the data report is actually something that's supposed to mirror the phone, correct?
No, not necessarily.
You just made my point formal. It's supposed to, but it doesn't necessarily always happen.
Well, you've said that term mirror image. That's not a term that's used. So
Okay.
I say no because it's an incorrect term. It's a data extraction.
What term would you use for what happened to the phone?
As far as when the phone is, to use a term dumped,
Yes.
so to speak. So the data is extracted from the phone. It's not a forensic action because the phone is still working. There's things going on in the background. You have to manipulate the phone in such a way to access the phone. So it's not, no mirror image. That's a term that is not used. So getting back to the texts, those texts from the screenshot, yeah, I'd say they're a little bit different than from what's on the phone that you can see that has been deleted.
And in fact, the forensic data reports use your phrase, the forensic data or the forensic extraction report right here.
Yes, the data extraction.
The data extraction does not contain the group texts that were screenshotted over to Officer, correct? Those are missing from the data extraction.
I'd have to look at it again. I might be thinking of a different group text.
There is if I were to suggest to you, query, there are text messages in the conversation between Will Little and MD on the night in question that includes the.
Familiar with that one?
You're familiar, you agree. Those have been manipulated and altered.
Yes, it appears that some of the parts of the conversation, yes.
And there's also a set of group text messages that are in the screenshot. So clearly at some point they were on the phone because Will Little sent that to Officer Kelly, and the data extraction does not include those. They're missing from the data extraction.
I'd have to look at it again. I mean, it's tough to memorize somebody's phone.
I understand.
As far as, because I'm thinking of another group text very similar to that one. And, I'd have to look at it with you, honestly, to answer that question.
Let me pose it as more of a hypothetical instance. I don't expect you to memorize everything.
I apologize. I'm not.
No, if in fact there is data that appeared in the screenshot that is not in the data extraction report, then that means the data extraction report is not accurate in terms of recovering every single thing from the phone. There may be things in the phone that did not appear in the extraction report, correct? If my postulate is true and those group texts are not in the extraction report,
It just means it's not on the phone anymore. It could be complete from the phone. Like I said, July 9th would have been the best time to have that phone. But as things happen, so when do I get the phone? November of 2017. And if things have been removed or whatever, they're going to be completely gone.
and of course, without that phone, we can never completely recover those, right?
But if I don't have it when I get the phone, it's not there.
If in fact there's data that was there when Will Little handed the phone, when Will Little sent the screenshots, and the extraction report doesn't have that data on it, and that means the data extraction report is not. That's the only point to make.
And I'm answering you by saying it's probably not in the data extraction report because it was not on the phone.
So the best source, coming full circle on this line of questioning, I'll leave it alone. Source for the data would be what? The most accurate data would be what?
The phone on July 9th, 2016.
And in fact, Will Little never even made these allegations till a year and 3 months after that, right?
I believe it was October of 2017.
Right. going back to what was discussed a little bit earlier out of your presence with the court, at what point did you return the phone back to whoever it was returned to?
December 18th of that same year.
The data extraction had already been completed
Correct.
on December 15th, correct?
I believe it was the 14th, thereabouts.
You recovered the phone.
Excuse me?
You recovered the phone from her on the. I'm sorry, my mistake. You submitted it for data extraction on the 14th and the 15th.
I believe it was done on the 14th. There'd been some issues with it, so we needed more information.
On the 18th, you then traveled where to return the phone?
I traveled to the residence of the Littles.
And who did you see there?
I saw Nick, Will, and Kyla.
To whom did you give the phone?
I believe I gave it to Nick Little.
In what condition was that phone? Was it in an evidence bag? Was it just free?
I just handed him the phone. It wasn't in a bag or anything.
What documentation did you produce to memorialize the fact that you had given the piece of evidence back to the individual or individuals that had provided the evidence in the first place?
Unfortunately, I was remiss and I didn't have them sign for a receipt.
And you're aware that Nick Little is claiming that he does not recall ever receiving that phone from you?
I am aware that they can't find the phone.
Are you aware that Nick Little is saying, I don't recall ever getting it back from Trooper Donovan?
I don't remember hearing that. I remember they were looking for the phone.
If Nick Little says, I did not get that phone back from Trooper Donovan, it's lying, correct?
Objection.
Sustained.
If, in fact, Nick Little claims that he never got the phone back from you, that would be inaccurate.
Yes.
That's all I have at this point, Your Honor. Thank you.
Mr. Glennie,
Are you aware of any conversations that were taking place other than with the phone, but with the use of a computer?
Yes.
Tell us about that, please.
As far as the information from the phone being backed up to like an iCloud account?
No, with respect to conversations that were taking place between Mr. Little and others by use of a computer as opposed to his phone.
Oh, there was text conversations because the phone and the MacBook were linked at some point.
And would that have anything to do with if he was using the computer being backed up on the phone or being kept on the phone?
The information would have been kept on the MacBook as well.
And with respect to having phones and returning phones or keeping phones, at the time that you were working, by the way, at this time, what was your assignment within the state police?
I was a state police detective with the State Police Detective Unit assigned to the Cape and Island District Attorney's Office.
And what's your current assignment?
I'm an investigator with the State Police Cybercrime Unit.
What does that mean?
I'm in a statewide unit and we investigate cyber crimes within the state.
All right. So with respect to returning the phone, tell us how that happened.
I had an interview to do with Kyla Little. We were done with the phone. So that evening when we went to the residence of the Littles, I just handed the phone back.
And was there any difference in the policy of the state police, if there was a policy, concerning the return of the phone to a person who would be a victim as opposed to a defendant in a case?
Past practice, common practice is that if someone is a victim or a witness and they're cooperating, we get what we need from the phone, in this case, a data extraction, and we return the phone back to them.
And that's what took place here, right?
Yes.
When you went, did that interview that you were talking about on the day you returned the phone, where did that take place?
At the Littles' residence.
And when you drove up to the Littles' residence, you had the phone. Isn't that correct?
That's correct.
And when you left, you didn't. Isn't that correct?
That's correct.
And that's because you gave it to somebody inside the house. Is that right?
I did.
Thank you. That's all.
Very briefly, Your Honor, if I could. Will Little didn't have his computer with him in the club car that night on July 7th, 8th of 2016, did he?
He did not.
So the text messages, et cetera, date entry would not have been on his computer, but been on his phone, right?
Correct.
And Trooper Donovan, you said that the common practice is, at least for you, if someone is cooperating and you're able to get data from their phone or from their whatever, computer platform that you have to be using, and they're perfectly cooperative, you get the data extraction that you need to, and then you get back the item. Is that right?
That's right.
What if that person is the central and sole witness of an event, and you're aware that that person or someone close to him with access to the phone has manipulated the data? Do you think that's smart to give that person back the phone?
Yes, he's a victim, so I gave him back his phone.
He's a claiming victim at that point. You hadn't finished your investigation, sir.
I feel that I would treat that person as a victim irrespective of what you just said. So.
And if, in fact, you knew that, let's use your word, that victim had altered data on the phone, you think it's a good practice to hand the phone right back to the person who's admitted having altered the data?
The data that she told me she altered had to do with frat boy activities.
But you heard that's the problem, correct?
Yes.
You took her at her word.
I did believe her.
Thank you, Your Honor. That's all I have.
Nothing for thank you.
thanks, Drew. We can step.
Thank you, Your Honor. I want this.
Thank you. Although I think we've already, this one's been marked. This was an extra, I think. So we can give it. All right, the folks, the next witness, what's your pleasure? I'm inclined to go with Mr. Little, but you tell me. No, that's the son.
William Little.
Yeah, please, son. Yes. Folks, if you want to stand up and stretch between witnesses, you can do that. Can't drink water, but you can fall.
Sir, you solemnly swear or affirm the testimony you give in the following hearing?
I do.
Thank you, Your Honor. Mr. Little, what phone did you have? Can you describe the phone that you had on July 7th and 8th, 2016, please?
It was an iPhone 5S.
How long did you have that phone?
At least a year or two.
Who paid for that phone? In other words, whose account was it under?
I believe it was under my mother's account.
During the course of the evening of July 7th and 8th, did you engage in text conversations with any individuals?
Yes, I did.
There's been an individual whom we have named MD as a set of initials, and I'd like to show some deference for that naming if you wouldn't mind. Do you know who I'm talking about?
I do.
That's a female?
Correct.
Did you engage in text conversations with MD that night?
Yes.
Did you also have text conversations with other individuals in a group text format?
Yes.
Who are those individuals?
There are 7 of them.
Can you name them for me, please?
Yeah.
You want to stick with initials in this case, or I don't know?
Not in this case. I think everybody's over the age of 18. And all right. Can you have the name, sir?
Yeah. So Will McMillan.
Okay.
Jack Henderson.
Okay.
Henry Birmingham.
Got it.
Jake Doherty.
All right.
John Hargraves.
Okay.
Brandon Minor.
Minor?
ER.
ER. Okay.
Is that 7?
Let's see. I think that's 6.
And Kevin Boland.
Okay. Got it. There was a back and forth conversation between yourself and MD during the course of that evening, correct?
Correct.
A running commentary, if you will. Is that right?
Yes.
There was also a running commentary between yourself and the group you just described, correct?
Correct.
That running commentary included text messages as well as some Snapchats. Is that right?
Yes.
And snaps, describe for us what snaps are and your understanding of them.
Just describe a typical Snapchat. Is that what you're asking?
What's the difference between a snap and a text?
A Snapchat is a picture which you can attach text or other things to, as opposed to just a message.
And is the algorithm such that it disappears?
I believe so. I don't know really the technicality of Snapchat, but yes, I believe so.
But you do know a snap goes away.
It goes away unless you save it, correct?
Okay. And there were also photos bounced back and forth on text message, correct, that night?
I do not recall.
All of the data, and when I say data, I'm speaking about it in the broadest term, Mr. Little, the data that was going back and forth. In other words, text messages between you and MD, text messages among you and the 7 others on the group chat or the group text, the snaps, etc. That's what I mean by data. All of that data was maintained on your phone that night, at least that night, correct?
Correct.
Okay. When did you first notify the police about these allegations that you've made?
I do not remember the exact date.
Does October 31, 2017 sound approximately correct?
Approximately, yes, but
About a year and 3 months after the event.
yes.
I mean, you didn't go to the police the next day,
No.
the next week,
No.
the next month.
No.
You didn't even go within the next year, did you?
I don't believe so.
When you contacted Officer Kelly and originally made your complaint, you sent him some data following your initial telephone conversation, correct?
I'm not sure if it was on the exact same date that I contacted him, but yes.
Joel, take a look at these 3 pages and just tell me when you're familiar with what's on these 3 pages.
Yes, I'm familiar with them.
These are the screenshots you sent Officer Kelly that night, right?
Correct.
Mr. Little, I'm not going to mark this, but if you don't remember the date, and this might refresh your recollection, you see the email that starts off, "Hey, Chris,"
Yeah, I see it.
and Officer Kelly's first name is Chris, correct?
I believe so, yeah.
Is that an email to Chris Kelly?
Email to Chris Kelly, yes.
And that date is what?
November 2nd, 2017.
Okay. So it'll be 2 days after your initial telephone call with him, which was on October 31st.
I believe so.
And attached to this email was those 3 screenshots.
I believe so, yes.
Okay. Mr. Little, did you have a conversation with your mother about this incident at all before you went to the police?
I don't specifically remember, but I have had conversations with her about it, yes.
Okay. In fact, you had a conversation with her about it the next day.
I don't recall.
During the year, and let's call it a year and 3 months, July, August, September, October. Yeah, year and 3 months. During that year and 3 months, how many times do you believe you discussed with your mother, Heather Unruh, circumstances of that evening specifically?
It was a long time ago. I don't recall.
You don't recall?
I do not recall, no.
Was it more than once?
Yes.
More than 5 times?
I am not sure.
You think it might have been fewer than 5 times in that year and 3 months that you ever mentioned being in a bar with Kevin Spacey and the allegations that you've leveled against him? Think it was fewer than 5 times?
I don't remember.
I object. I'm just unclear about whether we're talking about whether there were texts between him and the mother, or is this any conversation?
Any communications?
Okay.
Sorry, if I wasn't clear, allow me to clear that up. My apologies, Mr. Little. Any communications at all? Person to person, text messages back and forth to your mom, emails back and forth, telephone calls, smoke signals.
Any communication with my mother? Yes.
How many times would you tell the court? How many times would you estimate you spoke about this incident with your mother? I spoke or communicated with your mother about this incident.
I'm really not sure.
Okay, now let me go back. Let's see if we can estimate. I don't want you to guess. We can at least estimate. You were there, we weren't. Was it more than 5 times, you think, in that year and 3 months?
More than 5 times? Yes.
More than 10 times?
Like I said earlier, it was a long time ago. I'm really not sure.
You discussed the fact that you had text messages with your mother.
Yes.
Matter of fact, your mother asked to see the text messages, didn't she?
I don't know.
Before we get to her, she's just waiting out in the hall. She testified too. Is it your testimony that you don't know whether your mother ever asked to see your phone and those text messages about the incident involving Kevin Spacey? You have no idea.
Okay, objection. Unless this is limited to him. Unless she's talking about, she said to him.
I am. I'm talking about conversations with your mother, Mr. Little, about your phone, specifically as it relates to the allegations July 8th, 2016 against Kevin Spacey.
Are you asking specifically if she requested to see them from me?
Did you ever show her your phone?
Yes.
How many times?
I don't know.
Did you show her your phone because she asked to see your phone? Or did you show her your phone because you said, Mom, look at my phone?
Once again, I am not sure of the nature of how it came up, but it came up.
Did she see the phone before you went to Officer Kelly?
I'm not sure.
Did your mother ever express any concern to you about the nature of the text messages that were on your phone before you turned that phone over to Officer Kelly, before you contacted Officer Kelly?
Do not specifically remember if she had any concerns.
Did you ever talk to your mother about deleting any of the embarrassing text messages from that night?
I do not recall ever speaking to her about deleting any messages that night.
What was the reason that your mother wanted to see the phone? Why did she say she was interested in seeing the phone?
I don't remember her reasoning. But like I stated earlier, I'm not sure if she requested it or if it just came up.
Well, if she didn't request it and it just came up, and I'm not being coy or flip, I'm just trying to drill down on what the actual facts are. If she didn't request it and you told her you wanted to see the phone, why did you ask her to look at the phone?
I didn't say that I asked her to look at the phone.
Or they asked to see it. One of the two. There's really no other middle ground. Which was it?
I do not remember. It was a long time ago.
And you now say that you don't remember if she expressed any concerns about what was actually on the phone.
Correct.
Did she have your password?
I might have given it to her at some point, but I'm not sure at that time that she had it.
If she didn't have the password at the time that she first saw the data, you would have had to have opened the phone for her so that she could review the data.
If that was the case, that would be correct.
Did you point her to the text messages on the night in question between yourself and MD?
Once again, I don't recall.
Did you point her to the text messages among yourself and the 7 individuals on the group text?
I do not recall.
Do you remember that she actually did, however she got to it, do you remember her actually looking at the texts between you and MD?
At which time are we speaking?
Before the phone was turned over to the police.
I'm not sure if she looked at it at those specific screenshots or strings of messages, but not with me.
Not with you?
I did not look through them with her.
You never saw her look through the phone at the text messaging between yourself and MD on the night in question?
I was at school at the time that the phone was handed over.
Right. I'm talking about, before October in 2017, before you went to the police. All I'm trying to get to, Mr. Little, is, and I understand your memory stated, I understand that. All I'm trying to get to is, did she scroll through the the text messages between you and the group?
I don't remember.
Do you remember her saying anything to you about the text messages?
No, I do not.
Never indicated to you any concern about the contents of those text messages?
I'm not going to say that she never did, but I have no recollection of speaking with her about any concerns.
So she might have.
She might have.
Did your mother ever advise you, Mr. Little? Did she ever say to you, you need to get rid of some of those text messages?
I don't remember, but I don't believe so.
Do you think if your mother told you to delete or alter text messages before you went to the police, you might recall that?
I would like to think I would, but I'm not definitive, so I'm sticking with I don't definitively remember.
But she might have.
Theoretically,
Yeah.
she might have.
And theoretically, you might have followed her instructions.
If we're talking theoretically, the answer is, wait, repeat the question. Sorry, I didn't quite understand.
You might have followed her instructions to delete some of those text messages.
Had she done that, I would have acted on my own free will, if that's what you're asking.
And done what? Deleted the messages, right?
I object. This is all a question that he doesn't remember whether he did or not. He can't give a definitive answer, he's saying.
I understand. Maybe another question on it, Mr. Jackson, then you can move on if you want.
I think we've got what we needed. Nick Little, your father. By the way, and I apologize, I've called you, or I've referred to you as Will Little. I'm assuming that's short for William?
Correct.
Okay. Is your father also William Little?
He is.
Okay. For purposes of my discussion, because you're both named the same thing, I don't mean to be rude or insensitive. Is it okay if I refer to your dad as Nick Little instead of William Little?
Yes, that's okay.
Nick Little, your dad, did you ever let him see any of the text messages that we've been discussing? Either the text between you and MD or among the group?
I don't remember.
If he did ask, in fact, to see those messages, is that something that you think you would recall? Looking at your phone, your dad looking at your phone?
My father has seen the contents of my phone before, but I wouldn't say it's a regular event.
Do you think he saw the contents of your phone before you went to the police in this case?
I'm not sure.
You've also spoken to Mr. Garabedian, correct?
Correct.
Did you ever show him the phone or hand him the phone?
I never personally showed him the phone. I never personally handed him the phone.
So to your knowledge, well, let me rephrase that. You never had anything to do with handing or giving Mr. Garabedian that phone ever. It was never in his possession based on anything you did, correct?
Correct.
Okay. On October 31st, let's talk about the interview that you did with Officer Keller. Okay, on October 31st, 2007, you reached out to him and you had an interview telephonically, I think, correct?
Correct.
You provided him with what you claim to be an oral narrative of the events of that evening. Is that right?
Yeah.
But during that oral narrative, you never mentioned any text messages, group chats, nothing until he asked, were you texting that night? Was there any text communication, et cetera? At which point you admitted, oh yeah, there's some text on. That's how that went, correct?
Correct.
In other words, had he not specifically asked you about text messages, you didn't mention it.
I would have mentioned them.
But you hadn't until he asked, correct?
As far as I am aware, yes.
You told him about texts between you and MD, right?
I believe so.
And you also told him about group texts that you had with the 7 others.
Yes.
That was the foundation for what you emailed him later on November 2nd that I showed you earlier. Those 3 JPEG, meaning photo screenshots, correct?
Correct.
Mr. Little, before you sent those screenshots, did you in any way change, delete, manipulate, or alter any of those text messages, either between you and MD or you and Richard?
I provided what I had available to me because I was at school.
Okay, that's not an answer to my question. So let me ask it again. Before you handed those screenshots over to Officer Kelly, did you in any way change, alter, manipulate, or delete any text message about this event from your phone at any time for any reason?
On one of the screenshots, one half of the conversation is missing, I believe, but I did not delete any information.
How did half the screenshots end up missing?
I'm really not sure. You'd have to ask some kind of expert on phones. I'm not sure.
So when you opened up your group messages, half of the messages just vanished.
Like I said earlier, I gave what I had available to me at the time, and I did not manipulate any of that.
When you say you gave what was available to you at the time, what do you mean by that? Explain what you mean by that explanation.
I was in my sophomore year at college, which is in a different state from my hometown, and I didn't have a lot of this available to me, including the actual phone. And so I gave what I had available. I gave the screenshots and the messages that I had that were available to me at the time.
Would you agree, Mr. Little, you've used an iPhone, you're an iPhone generation young man, right?
Correct.
You're super familiar with iPhones.
Yeah.
You could probably pull out text messages from 5 years ago, right now,
No.
if you hadn't deleted them, correct?
Would you like me to explain?
Let me ask it a different way, because I know you've gone through several iterations of phones and there's been backups and you've lost things.
I have tried to go back and find the conversations, and due to a variety of circumstances, they were not there. Those circumstances were not related to any deletions.
Text messages do not simply delete themselves, do they, from an iPhone?
No, they do not.
So if they're not there, somebody had to have done something to remove them from that phone.
Unless there was some kind of error with the phone.
Unless there's an error with the phone. But assuming that there's no error with your iPhone 5S, and we only got partial text messages with specific deletions in a conversation, someone had to go in and manipulate those conversations and delete certain things, right, Mr. Little?
Repeat the question one more time, please.
Mr. Little, if we have text conversations between you and MD that night that are on a screenshot and a forensic report shows that true, and part of the deleted cache on your phone, parts of those conversations were missing and taken out. Someone had to have done that. They don't just evaporate on their own, correct?
Objection, Your Honor. He can answer to what he did. He can't answer what somebody else may or may not have done.
Well, he may be familiar enough with the phone to say, you know, my phone and messages don't just disappear. I mean, that's, but certainly to Glennie's point, the question is whether or not he did it.
I understand.
I have no knowledge of any deletions of messages on my phone, if that answers your question.
And you're sitting here today testifying under oath that you are not the one that's responsible for any of the deletions on the phone, right?
Correct.
Look, you've already glanced through screenshots that I provided you earlier. If you look at this document, if you've not seen before, on the left, could you compare, just very briefly, just scroll through and compare what you see on the screenshots to the column on the left, not on the right at this point, but the column on the left, and tell me if you agree that those mirror the screenshots. In other words, they've simply just typed out again.
Would you like me to go through the whole thing?
Just glance through. There's only 3 pages. If you just glance through, I think you'll find that the left-hand column mirrors exactly what the screenshots are.
Yeah.
Okay. You'll agree that the left-hand column is a mirror of the data. I know it looks a little different. It's in a column form or a table form, but it mirrors the data that's on those screenshots, correct?
One more time.
The left-hand column, just the left column of the 3 pages, mirrors what's on those screenshots that you sent to Officer Kelly, correct?
Yes.
And there's timestamps next to each one of those, correct?
Correct.
Okay. You're aware that there was a forensic data report or forensic extraction report that was done on your phone. Is that right?
Yes.
Okay. On the right column, assume for purposes of my questions that this is exactly from the forensic extraction report. Okay?
Okay.
On the first page, highlighted in red, I know maybe a little tough to see, but you can see, for instance, there's a text that says, like he's hanging around me in the bar, number, he asked me to come out. See that on the left?
Yes.
But on the forensic extraction report, it says, like he's hanging around me in the bar, he's got my number and asks, and it stops at ASK. It doesn't go any further. If I told you that the right column was from the forensic extraction report, you would agree with me that that is not accurate. It's not an accurate mirror image of that text, right? In other words, there's some characters and letters missing.
I would agree that the two of the things that I'm looking at right now are slightly different. Okay. Yes.
Now, turn to the second page, if you would. I'd like you to concentrate on just what's in red on the right column. You see on the left column, it's blank.
Yeah.
On the right column, there's some writing in red. Just read that to yourself, starting with, I hope he sees this RN, which means I think right now.
Correct.
Okay, take a look at that one. Look at the entry below that and the entry below that.
I see them.
If this is from the forensic extraction report, those 3 entries include MD texting to you, I hope he sees this RN. Hope he sees this right now. Then, is this the coworker? And then, hello. And then you begin with a response, right?
Correct.
So the third page, a couple of these categories, and Your Honor, I promise this won't take all that long. Again, just concentrating on the right-hand column in red. There appears to be a photograph. I don't know what that photo is because it's deleted. It's been missing. And then MD text, I really can't tell if you're kidding. I'm violently confused, right? On the left column, is that yes?
One more time.
She writes, I can't really tell if you're kidding. I'm violently confused, correct?
Correct.
On the left column, it's blank. Those texts are not in the screenshots.
Those texts are not in the screenshots.
Okay. And then down from that, in the second column of red, it says, forgive me, quote, holy shit, then slowly back away, OMG, WTF. OMG means, oh my God, and WTF loosely translated into what the F one, correct?
Correct.
And all four of those texts were from Molly Doyle, from MD to you, correct?
Correct.
Your Honor, if we could have that. That was my bad. We can have that straight.
That's
And I would appreciate the court admonishing I realize that's my bad, but
Oh, listen, it
we can have the respect
happens.
of
It
the
wasn't
media not to
intentional,
necessarily publish that name.
just
I would appreciate it.
if you happen to hear that, don't put it in any of your stories. Stick with MD. Thank you.
Thank you. My fault.
No.
And then there's a fourth category or a fourth set in red that starts from MD, ha ha ha, holy F, get out of there. That's creepy, OMG. I really thought you were kidding. She probably meant, I really thought you were kidding. And then finally, quote, did you let him teach down your pants and feel your dick?
And then followed by the help me text.
Followed by help me. If you look in your screenshots, Mr. Little, every single one of those categories. Category 1, MD basically saying she doesn't believe you. Category 2, instructing you to just walk away if in fact that's what's happening, just go away. And number 3, category 3, evidence of potential consent. All of those were deleted from the screenshots, or missing from the screenshots that you sent to Officer Keller. Is that right?
Yes.
Yet the word help me were kept in. Is that right?
Which words were kept out?
Help me was kept in, right? Is that yes?
Yes.
Mr. Little, you're aware that under Massachusetts law, deleting, altering any document used in furtherance of a prosecution, any document or object used in furtherance of a prosecution is a felony offense punishable by state prison.
Correct.
You're aware that general law, chapters 268, section 13E provides, quote, whoever alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the record, document, or object's integrity or availability for use at an official proceeding, whether or not the proceeding is pending at the time, shall be punished by imprisonment in state prison. You're aware of that law?
I was not previously aware of that law.
But you are now, correct?
Correct.
In other words, deleting text messages from your phone before you give them to the police, right?
I object to that.
Well, all he's asking is whether or not deleting it would make him subject to the law. I think it's a
Well, it's not. He's asking if any deletions from his phone would result in him being able to be charged with something, and that's not the state of the law. That's not the case.
Well, I think it's exactly what the case.
No, come up for a minute, would you? Both of you. Sir, I'll tell you what, you may step down for the moment. You're probably going to be called back up, but for the moment, sir, you can step down. Margerson and Ms. Donovan, would you come up, please? So we'll take it with respect. Agree with you. It may cause a problem down the road. Lenny, you may want to consider whether or not you want to take this individual's assertion of a Fifth Amendment privilege for the case in chief, which I know will pretty much end the case, or at least that's my impression. But you tell me, sir, what's your desire?
Well, we'll certainly have to consider that. I'm not prepared today to say what we're going to do.
All right.
Well, Your Honor, on that note, I think that I want to make sure that we are not waiving any privilege. Sorry, we're not waiving anything concerning his invocation of the privilege. He's got competent counsel. He's had a full and fair opportunity to be advised by competent counsel who has indicated that he is going to, she's counseled him to plead the fifth. He's indicated that he's going to exercise that privilege, which is absolutely his constitutional right. Obviously, one of the most protected constitutional rights. There's no reason to believe that between now and when we set a trial date and spend hundreds of thousands of dollars, tens of thousands of man hours potentially, and enormous blood, sweat, and tears getting ready for trial, that's going to change. I think the court could make an inquiry right now of Mr. Little. Do you intend to exercise your Fifth Amendment privilege throughout all proceedings? And if so, we would move to dismiss these charges today. This entire case is completely compromised. He is the sole witness, and he knows this. I'm not saying anything that he doesn't already know. He's the sole witness that can establish the circumstances of his allegation on the night in question. This case needs to be dismissed, and I believe it needs to be dismissed today.
I appreciate it.
I would just I'd ask for a week for me to be able to kind of assess our position and see where we are. We could, not trying to claim, I know what's going to happen, but we could probably take care of this over the phone next week, depending on what the decision of my office is. We have to look to see if there's any other.
Jackson, I get it, and you may be on the money once exercised, it may be pretty hard to get around this privilege at trial. I'm going to allow Mr. Glennie to have further discussions with his office, and the matter may well be dismissed for the reasons indicated. It's not going to happen today. So, all right.
Could we set another date?
We can do that, but let's hear from Ms. Unruh, I guess, whether or not she has it. That may be certainly not as important since the case revolves around this individual, and without him, Commonwealth will have a tough road to hoe. Where's Ms. Donovan?
Ms. Donovan, I believe, is talking to Ms. Unruh. Ms. Donovan just came up to me and said that Ms. Unruh wanted to speak with me. I said I didn't want to do that without Mr. Gary Beating being present, and then we were kind of busy here, so I have not been able to address that. But she was going to talk to her and come back. She still wished to speak with me. Maybe she doesn't. I don't know.
Why don't let's figure out. Go ahead.
The only other thing that I wanted to make sure that we put on the record, just sort of prophylactically so it doesn't happen again, Mr. Glennie was very kind and pulled me aside a few minutes ago and indicated that Ms. Unruh, notwithstanding my motion to exclude witnesses, which my fault, I'll hoist myself on my own petard at this point because I didn't know the right verbiage, I should have made a motion for sequestration.
Right.
I did not know that. I've now learned it.
Right. So she's been with others concerning
I
testimony?
think it's further than that. I think she's watching the proceedings live, which is exactly.
No, it's not. That's entirely inappropriate. You don't need extra language to know that that's wrong. So
I think we knew better.
Yeah. There's a reason why she stepped outside.
Correct.
Not to watch TV about the proceedings.
Correct.
Ms. Donovan, with respect to Ms. Unruh, do you find that she has a privilege?
I do not, Your Honor. I spoke to her. I explained to her what the ramification for what the Commonwealth would have to do, yes, or what she possibly would be charged with. Based on what she has told me, that she doesn't have to do.
So then she's prepared to testify in this case. We still have the issue of whether she crossed the line in terms of sequestration. I understand.
And the only thing I'd say in that regard, and again, Ms. Unruh was not one of the Commonwealth witnesses today.
No, I know.
It would be that, there was a statement that was made, and I forget what the word was that used. It wasn't sequestration.
Motion to exclude.
Right. And I took that to be a sequestration order, of course, but I'm an attorney and she's not. And I think that, she may not have understood the full ramification of what sequestration may have meant. But, he did say during that motion that he didn't want them to hear the testimony. And I don't know that she did. That, it may be something.
Let's bring her in and inquire of her whether she was, in fact, watching TV throughout these proceedings.
Can I speak with Unruh privately before we bring in?
Go ahead.
This is the first I've heard of this.
Go talk to her. And Ms. Donovan, if you want to talk to her again, you can do that. But one way or the other, let's either get her on the stand or she can exercise her fifth. Let's go.
My client takes.
Any reason for this gentleman to stick around, folks?
No, Your Honor, except I think that he should be instructed that he shouldn't talk about what's happened here with any other potential witnesses.
I'm joining the request for that order.
Well, that presumes we're going to have a further witness. Maybe we will. A little again. Yeah, you may not discuss what you've observed or what you've testified to with anyone else connected to the case. You can talk to counsel, but you cannot talk to other prospective witnesses. You understand, sir? Thank you. You may step outside.
Okay.
Folks, 5 minutes. Hopefully that's enough time. We'll come back and then we'll.
All rise, please.
The right, should anything come up, to be allowed to consult with her during testimony.
Can, although we're going to be in the same situation where we get down the road and all of a sudden the privilege is asserted.
That's right.
Toward the end and everything gets stricken, which.
Your Honor, to the extent if it goes on the road that it's already been down, I would say there is that.
Sure.
With regard to the assertion that was made before the recess, watching it, follow, so that doesn't change.
All right. So she's going to say the other issue may be that there's a piece of paper in the file that I thought indicated that she admitted to deleting items from the phone, which in and of itself may create Fifth Amendment issues. Not saying that it does, but there is that piece of paper that's there. So she's going to be asked about it. Go ahead.
Yes, I did speak to her about that, and I believe the questioning also came up with regard to any information that had been taken. She states to me, based on the information that I've given to her, anything that was taken, removed from the phone prior to giving to the police was not subjected to a fifth.
And I'm sure you looked at the statute because the statute indicates that the proceeding doesn't have to be underway. So you can engage in this activity in advance of, and you may still be brought within the.
What I would suggest, Your Honor, that the testimony would come up that anything that was taken was not related to the investigation.
Okay. All right.
And I believe that is what was related to Truth Donovan was provided.
I understand.
But again, I would reserve the right, Your Honor, if we go down the road that I feel allowed to consult with her if anything all the time.
Well, listen, I'll give you a little leeway there, but I'm not going to be. Every other question, she's going to waive it. She's going to waive it. And she's going to be stuck with that waiver and the testimony that she offers. Let me just thank you very much. Ms. Jackson, I don't know what's going to happen with respect to Mr. William Little, whether the case is going to continue or collapse based upon his assertion of a privilege. And Mr. Glennie wants the opportunity to talk to his office. I understand that. we can continue with the testimony. I'm not adverse to that at all. Or we can postpone it and come back and see whether or not it's necessary. But you folks tell me what I mean, you're the one who comes from a far distance. So you tell me what works for you, sir.
Well, thank you, Your Honor. I appreciate that. One thing I would ask counsel to consider, because I know she's coming very late to the game, and I get that. I empathize with that. I would not necessarily want to be in her shoes right now. I think it's important to understand, and she may want to readdress this issue with Ms. Unruh. We are not discussing simply the deletion of text messages from that night, which we know somebody is deleted. Where that evidence goes, I don't know. She's certainly going to be asked about that. The second tranche of evidence is the group text messages. We know that those were scrubbed from the phone somehow and didn't even end up in the forensic data report, the extraction report. But there's a third level, which Ms. Unruh may think is innocuous and counsel may not have considered, which is Will Little is the central witness in this entire case. His credibility is at the forefront of this entire case and the prosecution's case. What she's admitted deleting is impeachment material about him, his credibility, his veracity, his ability to remember what he's got on the phone. Otherwise, that she calls, and she's the only one in this room. Well, she's not in the room now, I hope. She's the only one among us who knows what those, quote, frat boy activities are. Trooper Donovan certainly didn't. But if she's gone through and scrubbed that phone to make him look like some sort of choir boy, that is, according to the general law under Massachusetts, that is altering, destroying, mutilating, or concealing a document or a record with the intent to impair that record's integrity. Period. Full stop. There is no way that if she's already admitted, which she has, that she has compromised the integrity of that phone before giving it over to the police, even though she may deny that it dealt with text messages or group texts, she certainly admitted that she's scrubbed the phone and sanitized the phone in terms of her son's overall credibility. And that's not fair for us. And I think that should be taken very seriously in terms of a prosecution. She could be prosecuted for that in and of itself. So I want to make sure that counsel's aware that it's not just her denial of the texts. It's the fact that she admits to having scrubbed the phone to make him look other than he actually was.
Well, that may be your characterization. I mean, that certainly she did delete items. It, I guess, remains to be seen when she takes a stand. So, Donovan, you tell me, do you want to talk to her? Do you want to just go forward? And the other question is, Mr. Jackson, do you want to continue with the hearing today?
I do.
Okay. All right. So go ahead. Do you have a thought? Do you want to?
The question I would ask for the court, for Mr. Jackson, and for the Commonwealth would be, to what extent the phone was being used. If the question is, this statement's being made that Ms. Unruh deleted messages from that night, or the question is that she had deleted anything from after that point that to some extent that had nothing to do with that night. To what extent was the court order having to do with the phone? Was it for everything, or was it for
But
that?
you know what? You can't. That's a pretty hard line to walk. I mean, she takes the stand. Mr. Jackson is going to ask her about the phone, whether she got it, when she deleted it, she turned it over, conversation she had with her son. All of that's coming in. And at that point, you can't say, no, wait. I mean, the same testimony for the most part that came in from Mr. Little, you can bank on that coming in with her as well. And I can't allow you to jump up and object when there's a question that you don't like.
And the only thing I didn't mean to interrupt, but I did want to answer counsel's question very directly. The preservation order, which I think you were asking about, was the entirety of every bit and byte on that phone, that nothing was to be deleted, destroyed, manipulated, or altered on that phone at all.
That preservation order I entered.
That was the one on
January after the
January 7th, I think.
Right, and then it was expanded a little while thereafter. So
That's
her deletions, at least that we know about, occurred much prior to that.
Well,
it would seem
a few weeks ago.
January 2019.
I understand.
That's right.
I understand.
My question was whether or not the preservation order came into effect after Ms. Unruh had deleted anything. I will speak to her.
I don't know when she deleted stuff. It came into effect on January, and then it was expanded, I think, the next meeting, which was in February sometime.
Well, if the court, I will speak to her again. They explain everything again, and I'll make you already.
Fine. No, that's fine. What about Mr. Little? I mean, is there any indication or allegation that he deleted anything? And he's simply the one who may have received the phone. Certainly, you can ask those questions, but I mean, I try to move things along here. If we can't get to her, let's get to him.
The answer is we believe that both of them took part in deleting certain things off of the phone and sanitizing the phone.
Thank you. So he needs to be spoken to as well. Michael, you want to come into this? No, no. It's up to you.
I can't.
I appreciate it. Would you move to Mr.
Your Honor, I'm sorry. You said Will Little, and I may have heard Nick Little or vice versa.
No, I meant Nick Little.
No.
There's no issue there with deletion.
I do not have any, I cannot say in good faith that we have any evidence that suggests that Nick Little, the father, deleted anything. I'm sorry. I misspoke.
It's fine. So we don't have issues there.
Right.
You do want to put him on just to see whether he got the phone back.
It'll be short.
All right. So I think we can probably accomplish that while you're talking to Ms. Unruh, if that works. Scarbedian, you're welcome to sit and observe. It doesn't sound like that, we're going to be broaching Fifth Amendment issues with respect to Mr. Little's testimony. So let's bring him in. And if an issue presents itself during this examination, we'll stop.
So the testimony given the cause on here is.
All right, Mr. Jackson.
Thank you, Your Honor. Mr. Little, thank you for joining us this afternoon. I appreciate it. I have a few questions for you concerning one of your son's phones. Specifically, when I refer to his phone, I'm talking about the phone that was in his possession on July 7th and 8th of 2016. So we're talking the same language. You understand?
Sure, yeah.
Okay.
How many years ago?
Well, you tell me. When was July 2016?
Okay. Go ahead. What's your question?
It was I'm sorry, what was that?
What's your question?
Mr. Little, I'll ask the questions. You answer the question. Clear about our roles, okay?
I understand.
Gents, he was inquiring as to what the question was, Mr. Jackson. I think you both kind of had overlapping comments there, but go ahead, sir.
To answer your question, sir, it was 3 years ago today, July 8th, 2016, the phone that was in your son's possession. That's what I'm referring to when I ask you about the phone. Yes? You understand?
That's what you say, yes.
Okay.
Sure.
At any point, did you ask your son to look at his phone, that phone?
He looks at his phone every day. What kind of question is that?
Sir, hang on a second. Now, back to the point that Mr. Jackson made. Listen to the question and answer just listen to the question and answer just the question that's asked, sir. You don't need to go beyond that. If there's a further question, Mr. Jackson will ask it or Mr. Glennie will ask it, all right? So just focus on the question, sir, and we'll move through this examination real quickly. I appreciate that. Thank you.
Thank you. At any point, did you ask for you to look at your son's phone?
No.
So between July of 2016 and when this incident was reported to the police 15 months later, October of 2017, did you ever see his phone or the contents of his phone?
I did see his phone, yes.
Did you ever look into the contents of the phone?
I did not look into the contents of the phone.
You never looked at any text messages or group chats?
That said, help me.
Okay, so you did look at his phone.
He showed me the text that said, help me.
Okay.
Does that help you? Because I think there's a clear text there that...
Sure. I appreciate that.
This is going way too far.
Listen, I'll decide that. You answer the question, sir. Go ahead.
Thank you. If you don't understand my question, just ask me and I'll repeat it. Thank you.
I think you've had way too many questions that have gone way too
Listen
far.
to me. You keep this up, I'm going to hold you in contempt. This is a criminal proceeding, and you will cooperate, or as I say, you'll be held in contempt.
I understand.
I appreciate that. Go ahead.
Thank you. What were the circumstances in which you looked at his text messages?
He showed me the text.
When was that?
I can't tell you an exact date. I don't recall the exact date.
Can you give me an idea of the month or even the time of year?
It was the week when it happened.
Okay. And
do you want to let everyone know what that was that happened?
Who was there when you looked at his text
I
messages?
asked you a question.
Listen, are you not hearing me, sir?
I am. I'm sorry. Look, I'm sorry. My son...
Listen to me. This is not about that at this moment. It's about what you know.
But has turned into that.
You listen, you're real close.
I'm sorry.
May I, Your Honor?
Yes.
Thank you. Let's try this again, Mr. Little. Approximately, if you don't know the day, approximately when was it that you looked at his phone?
I don't know.
Do you believe, as you testified just a couple seconds ago, that it was the week of the alleged incident?
Yes.
Who was there when you looked at that phone?
My son and my wife.
Did she look at the phone as well?
She did.
So the two of you as parents, Will Little's parents, scrolled through the text messages he had on his phone, correct?
No, we did not scroll through his text messages. We looked at the messages that he showed us.
Just the messages that he showed you? Did you have any concern, Mr. Little, with the contents of any of those text messages?
I've already told you the concern I had. Yes.
Okay. You mentioned the help me text message, correct?
Yes.
Did you see other text messages on the phone?
No.
The only text that you saw on the screen on his phone was help me that he showed you?
I saw other texts, but the one that stood out was the one that said help me. As a father, that stood out.
Did you at any point suggest to your son that he get rid of certain text messages?
Absolutely not.
Did you have a conversation with your wife at any point between then and now?
No.
About, well, let me finish my question.
I know what your question is. Go ahead.
Well, you don't know what my question is.
Sorry,
sir.
go ahead.
At any point between then and now, did you have any conversation with your wife, Heather Unruh, about the contents of those messages?
What is your question?
At any point between July of 2016 and today, have you had any conversations with your wife about the contents of those text messages?
Isn't there a spousal privilege?
Sir,
I would have to agree.
hang on,
What is
hang
your
on.
question?
Sure, hang on. Do you have anything to say about that, Lenny, in terms of a spousal privilege? Normally, if there's somebody else in the room, then that privilege would not apply. And no, I think he indicated that he was doing it with his son. Go ahead. What were you going to say?
I was going to say there's also a crime fraud issue if the conversation.
Well,
Text messages. And that's what I'm trying to get at.
go ahead.
Thank you. Do you have the question in mind? Or do you want me to repeat it?
What's your question?
At any point, did you and your wife, Heather Unruh, discuss the contents of those text messages? Yes or no?
Well, I would object to that unless somebody else was present. He's not asking like now when William was there. He's asking at any time.
I'll rephrase the question or follow on with another question. Who was in the room? Was there ever a time that you two discussed it, you and your wife discussed it with Will, your son, in the room as well?
I already answered that phone together.
Anytime after you looked at the phone that first, did you and Heather and Will discuss the context? I looked at the phone, Mr. Lou, but discussed what was on the phone. This text and that text and a group text and a chat and a video and this. No.
We're discussing the issue, not the phone. What we're talking about here is, are you talking about looking at what's in the phone, or are you talking about what's happening in the real world of what's happened here? Because we've been talking about what happened.
After you looked at the phone, what I'm asking.
The phone was not the issue.
Let me finish. Respectfully, you don't get to decide what the issue is, sir. The court decides that, okay? See if you can answer my question. If you don't understand it, tell me and I'll repeat it.
Repeat it. I don't understand your question.
At any point after you looked at the text messages with your wife and your son, did the three of you discuss the contents of those messages?
We probably could have, yes. We get back to the help me. There was what we thought was a crime here.
As a matter of fact, the topic, as you put it, came up multiple times before that phone was ever even turned over to the police.
The topic of what? What is your question?
The contents of that phone, the fact that there were text messages from that night. That was discussed among you, your wife, and
I think it's quite obvious. Yes, there were texts from that night.
That wasn't my question. See if you can answer my question. Did you discuss with your wife? I know there were text messages, Mr. Little. That wasn't my question. Did you discuss those text messages?
Yes.
Did you ever, or your wife ever, express concern to Mr. Little, your son, about what those text messages contained?
No.
Did you ever tell your son that you thought some of the text messages needed to be deleted?
No.
Before he turned it over to the police?
No.
Did you know that your son was going to turn over certain text messages from that night to the police?
When is the question?
At any point. At any point. Did you know before it happened, at any point before it happened, that your son was intending to turn over screenshots from his phone to the police?
I'm not even sure if I understand that question, Judge.
I appreciate that, sir.
I'll try to
Jackson,
rephrase it.
would you? Thank you.
Did you know, were you aware, Mr. Little, at any point that your son was intending to supply the police with screenshots of those conversations?
If I can recall this properly, I believe the police asked us to do that.
Okay, so that still doesn't answer my question. At what point did you become aware that your son was going to provide screenshots?
I can't recall.
Did you look at the screenshots before they were provided?
Can't recall. I don't think so.
Did the screenshots mirror the actual texts that you saw on the phone?
I have no idea. I didn't look at them that closely.
How about your wife? Did she look at the phone more closely than you did?
You guys going to have me answer questions for my wife?
Sure, it's what you observed. So if you observed
What
her
you saw
studying the phone, then you can answer that yes.
What
or
is your question?
Did your wife, in your presence, did you ever observe her looking
No.
in more detail than you did?
No.
Okay. Did you ever see her looking at the phone or looking at the text messages after that first week after the incident?
I can't recall. I have no idea.
Who turned that phone over to the police?
Will did.
I'm sorry?
My son did. Will.
Were you there?
I don't recall if I was there at the time. I don't know.
But you specifically recall that it was Will Little, your son, that
It's his phone. They asked him to turn over the
Sir,
phone.
I'm going to ask you one more time. Please wait until the end of my question before you interrupt me. Okay, that's the only way this can
You just don't know how to answer questions.
Sure.
I'm working on that.
Listen.
Okay, go ahead.
Hey, listen. You want to take a break?
No, I'm fine.
You need to compose yourself
Yeah.
because you continue to go beyond the limits of the question.
I'm sorry. Go ahead.
We're ready?
Yeah, we're ready. Go ahead.
Is it your testimony that it was your son who physically turned the phone over to the police when it was turned over?
Yes.
Were you there when he did that?
No.
When was that?
I don't know.
Can you give me a month or a year?
When the police started investigating and they asked for the phone, that's when we did.
So you believe it was right around the time that you first reported the incident to the Nantucket police, Officer Kelly?
I don't know. It's when they asked for it.
But you have no idea in your head when it
No.
was. Who got the phone back from the police?
We don't know. We don't think we have the phone.
Do you remember being home on December 18th, 2017 with Kyla and your son, Will?
I not recall that day being home.
Do you remember where you were?
Probably at work.
Do you remember being contacted by Trooper Donovan from the state police about that phone?
Not personally, no.
Do you remember Trooper Donovan calling you and making an appointment to return the phone to you?
No, he didn't make an appointment to return the phone. He made an appointment to talk to my daughter.
When he spoke to your daughter on that same occasion, were you there?
I believe I was.
Was that at home?
I believe so.
Do you remember him handing you the phone on that same date?
I do not.
Oh, sorry, I missed that response.
I do not.
Do you remember Will being home at the time that your daughter was interviewed?
I do not.
Do you remember Trooper Donovan handing Will the phone in your presence on that date?
I do not.
Did you ever receive that phone in any way, shape, form, or fashion back from the state police?
I don't recall.
If you had received that phone back from the state police, do you think that's something that you likely would have remembered?
Objection.
Oh, he's answered.
Yes.
So is it your testimony that in point of fact, you did not receive the phone back from the state police?
That's what I've said.
And I'm not trying to be coy. As you sit here today, sir, you have never received that phone back.
I don't recall getting the phone back.
If you had gotten that phone back, what do you think you would have done with it?
Objection.
I'll sustain it. I mean, it's
All right, I'll ask you a different question, Judge. You knew, Mr. Little, that relevant information to this case was contained on that phone, did you not? Including text messages and chats and things that we've been discussing, correct?
You do.
You also knew that if, in fact, this case were to proceed to trial, that phone would likely be used or be necessary in that trial, correct?
We did.
Mr. Little, did you have anything to do with getting rid of that phone?
No.
In your presence or to your knowledge, did your wife, Heather Unruh, have anything to do with getting rid of that phone?
No.
To your knowledge, did Will Little have anything to do with getting rid of that phone?
No.
As you sit here today, can you tell me where is the phone?
No.
In whose possession did you just personally, not what you've heard from others, but in whose possession did you last see it?
I saw it with my son.
And after you saw that phone in your son's possession, you've never seen it again?
And sir, just so we're clear, do you remember the date when you last saw it with your son?
I do not.
Okay.
May I have just a moment, Your Honor? I just need a quick second. That's all I have at this time.
Thank you. Lenny?
Sir, did you ever have the passwords to your son's phone?
No.
And the phone was the one that your son used, but it was under your wife's name in her account. Is that right?
I believe that's correct.
And you testified earlier that your son, William, turned the phone over to the state police. Is that right?
As far as I know, yes, that's correct.
What do you base?
Just my best guess on the police asked for him to give the phone to them, and he gave them the phone.
Yeah.
I just asked you to kind of look at this and just tell me if you've seen that before. And then you can.
I don't know that I have.
Okay. Have you had a chance to look at it?
I'm looking at it right now. Okay.
Just tell me when you're done.
Okay.
It's a form from the state police, right, indicating that Heather Unruh turned the phone over to Trooper Donovan, isn't it?
That's what it shows. Okay.
And you were asked if the last time you saw the phone, and you indicated that William had the phone when you saw it. Is that right?
That's correct.
Now, would that have been before or after he had gone to college?
I don't know.
And so is it fair to say that you never deleted anything from?
That's correct.
And no one to your knowledge, where you were present, deleted anything from that phone, did they?
No.
Now, do you remember a time, and I think you mentioned it, where your daughter was going to be interviewed? Is that right?
That's correct.
And do you remember who it was that came to do that interview?
Trooper Donovan.
Wasn't he with another trooper?
I believe so.
Taller, burly guy, bald?
I don't remember. I don't recall the list.
But you remember there were two troopers, right?
I believe so.
And your daughter was interviewed, wasn't she?
What's the question? I'm sorry.
Was your daughter interviewed when those troopers were there?
I believe so.
Was William there, if you remember?
I don't remember that now.
And just so we're clear, you're saying you don't remember receiving the phone back. Isn't that right?
That's correct.
You're not saying you never got the phone back. You're saying you don't remember getting the phone back, right?
That's correct.
Thank you. That's all.
Nothing further, Your Honor.
Thank you, sir. You may step down. We all set with Ms. Unruh? At this point, do we know? Bring her in and find out what's happened. Actually, my feeling is that this testimony with Ms. Unruh, we may have about an hour before the folks leave that many of us have reservations on. I'm not sure about your reservations, but so we'll get as far as we can. If there's additional questions, if there are additional questions, then maybe those can be asked at a future date. Not that I want to do that. Go ahead.
I just want to speak to Mr. Jackson.
Sure, go ahead.
Yeah, there's another witness in Commonwealth. This is here, would be a very brief witness.
Sure.
It's Trooper Sergeant Scott Brightman. If you could in your next station.
No objection.
Thank you.
Scott Brightman, please. Sergeant Brightman.
Kevin, are they coming? Do you know, Brentman? All right. Okay.
Right here. It's right hand. Please start.
So this one you give the cause I'm hearing is the whole truth?
Yes. Start.
Sir, in a nice loud voice, could you state your name?
Scott Brightman.
And drawing your attention, sir, back to the date of Monday, December 18th, 2017. How were you employed at that time?
I was a sergeant for the Massachusetts State Police assigned to the Cape and Islands Detective Unit.
And did you have occasion that day to join with somebody and go something?
Yes.
And what was that?
I assisted Trooper Donovan doing an interview
And who was the interview? Well, where was the interview?
in Dover, Massachusetts.
And was it the daughter of somebody involved in the case?
Yes.
All right. Now, with respect to a phone, tell us whatever you recall happening with respect to a phone that Mr. Donovan had.
We arrived at the house. We were there to interview the daughter. We came in the home. The dad, Nick, was in the kitchen area at I would call it like an island area. He was doing some paperwork or something to that effect. Trooper Donovan gave him back the phone, and then we actually met in an adjoining dining room area where we actually interviewed the daughter.
Thank you. That's all I have.
Thank you.
Very briefly, Your Honor, did you get a receipt for the phone? I think you probably should have.
Objection.
I'll rephrase it. What's your normal protocol?
When returning items in evidence, we probably would get a receipt.
But you didn't in this case.
Correct.
That's all I have.
No?
No, Your Honor.
Thank you.
Thank you, sir.
You can step down. Stay right there for a second.
You solemnly swear or affirm the testimony you give in the cause I'm hearing is the truth?
Hang on just a minute. Mr. Donovan, any change still, if there is a fifth, she's waiving it or you don't find it or?
Your Honor, there is a fifth, and she is waiving it at this time.
All right. So
I believe there's a fifth. I have advised her of it.
I understand.
She's waiving it, which is
State your name and your age, please.
Heather Unruh, age 52,
How far did you go in school?
bachelor's degree from DePaul University.
Any drugs or alcohol the past 24 hours? I know these are questions that I need to ask. So,
Yes, I've had alcohol in the last 24 hours.
but that's not.
Not today.
It's not impacting your ability to know what's going on here.
No, no.
You're not suffering from any impact your ability to understand what's going on here. Is that
No.
correct? I'm advised that by your attorney that after consultation with you, and I think Mr. Carabini as well, that at least Ms. Donovan is of the opinion that you have a Fifth Amendment privilege not to testify because by doing so, you may incriminate yourself and may subject yourself to criminal prosecution. Is that accurate that the attorney is of the opinion that you have a fifth? Is that right?
And that to me.
I'm further advised that although you may have a fifth, you're choosing to waive that fifth. Is that right?
Yes.
And so if you waive the fifth, you understand that you take the stand and you offer testimony that incriminates you, you can face prosecution. You understand that?
Yes.
Anyone forcing you to waive this fifth?
Nope.
Anyone threaten you at all?
Nope.
Anyone promise you anything?
Nope.
You had enough time to talk to your attorney about the case, or at least I should say?
No.
No, if that's the case, then
You have to make your mind up now, sort of.
well, that's true. But you know what? If you still need some time, then I don't want to put you on the stand if you're not sure about what you want to do. So tell me, are you comfortable taking the stand now and waiving the fifth, or do you have a different thought about what you need in terms of time with your attorney?
I have nothing but the truth to tell. So while I know it may be very unpleasant going forward, I believe I was raised to tell the truth and not be afraid to.
Well, I appreciate that. But again, if you may have this privilege, and I just want to be clear that you're going to testify despite the fact that nobody can force you to testify.
Yes, yes,
So you're going to waive the privilege for the reasons I indicated, freely.
yes,
Yes?
yes.
All right. I appreciate that. You may take a stand.
All right, thank you.
I'm sorry. One more thing. There was we excluded witnesses this morning. There was a report that you may have witnessed some of the TV coverage. Did you?
No,
All right.
couldn't see a thing.
No.
I could hear outside in the hallway the questioning that was going on.
Sure. Well, there's not much we can do about that. But
Yes.
all right. It's fine.
Thank you, Your Honor. Ms. Unruh, you indicated that you were raised to tell the truth.
Yes.
Let's talk about that for a second. If the truth is that you deleted or altered certain things on that phone, you're going to tell us that, correct?
Yes.
At any point, did you ask your son, Will Little, to look at his phone before it was turned over to the police?
No, I looked at his phone before it was turned.
Probably a bad question on my part. That's exactly what I was asking. At any point before it was turned over to the police, did you look at his phone?
Yes,
Okay. Was that upon your inquiry, or did he say, Mom, look at my phone?
I was inquiring about evidence I didn't know existed.
And that's what you put as evidence included text messages between him and a young lady that I'll refer to as MD. Do you know who that person is?
I do.
Okay, we're not going to, we're trying to say her name.
Yeah.
If we can help it. And then a group chat among your son and a group of other young men.
Yes,
You saw both of those sets of conversations.
not on his phone.
When did you see, or where did you see those?
He screen grabbed from his computer and texted it to me. And I had never seen them before. They were a bit shocking.
And those text messages were then, those the same screenshots that were provided to the police, to the authorities.
Yes.
Did you tell him to provide those screenshots to the authorities?
I can't remember if I provided them or if he provided them. I honestly can't remember. But yes, essentially, yes, thought they were very important to the case.
At any point, did you discuss with your son a concern that you had about the content of some of those text messages?
No,
Did you ever tell him that you believed that certain of those text messages could be exculpatory?
no,
Did you ever instruct your son to delete certain of those text messages?
certainly not.
Did you ever delete any of the text messages in the conversation between
No,
your son and MD?
no,
Did you ever delete any text messages between your son or among your and the group that was
no,
being texted back and forth that night?
no.
You had a meeting with Trooper Donovan on November 29th, 2017, correct?
Yep.
And that meeting was for the sole purpose of you turning over his phone to Trooper Donovan.
Yes.
Phone is basically like an electronic brick if you don't have a password, right?
Right.
You knew that. Trooper Donovan knew that.
Right.
I object to what Trooper Donovan knew or didn't know.
Sustained.
So you, I'm sorry, Judge. So you knew his password, Will Little's password.
Well, I didn't know his password until he gave it to me.
Right.
And then I knew it. I'd never been on my son's phone looking for anything before.
At some point, you learned his password.
Yes.
And that was before or after you turned the phone over to Trooper Donovan.
Before.
In fact, you were texting with your son on the same day that Trooper Donovan was going to come by and pick up the phone, correct?
I don't know. If you say I was, then I was. That's beyond my memory.
Well, let's look at a document real quick. This is a quick 3-page document that's from the quote-unquote Lantern Forensic Report. And if you could take a glance at that 3-page document, I know that's not something that you're familiar with, but if you could tell me after you've had a chance to look through it, if you recognize some of the contents of that page or those pages.
Yeah?
Did you and your son discuss before Trooper Donovan arrived at the house the fact that you were going to turn that phone over to law enforcement?
Oh, I'm quite certain. Yes.
In point of fact, Ms. Unruh, 40 minutes before Trooper Donovan's scheduled arrival at your house, which was 3 p.m., the scheduled arrival was 3 p.m., you and your son discussed what needed to be either deleted or manipulated on that phone, correct?
I don't see that anywhere in here.
Take a look, if you will, at the second text message down that indicates from mom at a 508 number. I'm not going to mention the rest of the number for privacy. Is that your phone number?
It is.
Okay. That text message says to your son, take a pic. I think your pictures are still ending up on your old phone, not messages, but pics. That's what that says, correct?
I don't understand what that means.
Well, you wrote it, Miss Unruh.
Well, I wrote it how many years ago? Take a pic. I think your pictures are still ending up on your old phone, not messages, but pics. I think that what this probably was me telling Will that there weren't any messages on there. There were pictures, but no messages. But I'm guessing this was a long time ago, and that's not descriptive enough for me.
Miss Unruh, the fact of the matter is that text message to your son is an indication that you and your son were discussing what was and wasn't on his old phone.
Oh, we were discussing that.
And you were concerned about what was and was not going to be on the old phone that you turned over to Trooper Donovan. correct?
How do you get that from this?
I'm asking you, ma'am.
No, but I don't know where you're going with it. I don't understand where you're going with it.
You were discussing 40 minutes before you were due to turn that phone over.
Yeah.
Had a discussion about which photos and which pictures and which messages were going to end up on the old phone. And you were concerned about that. And you sent that text message to your son in concern about what was and was not going to end up being on that phone.
This to me is more like, and I'm trying to interpret something that happened years ago, but this to me says more like, I am not a technology wizard. And for some reason, if he's sending me messages or something on that phone, I'm not getting them. So I'm saying, take a picture and send a picture. That's how I'm interpreting.
The easiest way for you to have turned over a pristine phone to Trooper Donovan would be to turn it off and just set it.
Yes.
As opposed to texting with your son minutes before he arrives, concerned, very concerned, obviously.
I don't hear anything in there that sounds very.
Take a pic, ... I think your pictures are still ending up on your old phone, not messages, but pics. You had determined that the messages were not getting to his old phone. You were determining what photographs or what data was actually getting to his old phone before you turned it over to the police.
I can't tell you that. I'm sorry. That is not a clear statement to me. I can't tell you that.
Concerned.
Possibly.
Ms. Unruh, I'll ask an expert.
I'm just trying to interpret.
Stop for a second.
You've answered the question.
Listen to it and answer it.
Okay.
Go ahead.
You were, in fact, concerned about the contents of this phone. Right?
I was, yes, some things.
As a mother,
Yes.
very concerned, as a matter of fact. And this is sort of where the rubber meets the road, Miss Unruh. Before you turned the phone over to Trooper Donovan,
Yes,
you accessed that phone, did you not?
I did.
You opened it up, yes?
Yes.
You started reviewing text messages, photographs, Snapchats, things of that nature.
I started looking for video. I was looking for video that I had no idea existed before that time, where Will told me, confided in me, that he had shot a video of Kevin Spacey sticking his hand inside his pants. And I went looking for that video because I thought it was very important.
If you knew that if, in fact, such a video existed, it was on the phone and it'd just be there. Turn it over to Trooper Donovan without you impacting the data on the phone, right?
I see what you're saying.
Is that right or not?
I was looking for video. I was looking for the video.
And you came across the phone too.
I did.
That included text messages, Snapchats,
Not text messages.
photographs.
Photographs and videos. I was specifically looking for that video. So I went through every video in his phone.
And in fact, the text messages would have been right there for you to see.
I didn't see them.
I'm not asking if you did. I know you're denying that you did.
Mhm.
They would have been right there for you to see if you wanted to, correct?
I don't know. Are you an expert on phones? Do they
Well, I
survive
have
after?
an iPhone, ma'am. You can just open up the texts.
This was a very old iPhone, and I don't know that things exist when you turn it off for a long period of time. Do the texts come back? I don't know. I can't answer that for you.
But you did scroll through the phone and find data that you didn't want the police to have, admittedly, correct?
Yes, and I was very honest with the police about that.
And the data on that phone included things like that you saw,
Mhm.
included nude photographs of girls taken by your son.
No.
Did it include racist remarks made by your son to some of his friends, racial epithets?
The only things that have, when I see something from my son, and this goes to his Venmo account, and there were some words on it that were rough and sounded racist out it.
Like what?
I don't know. It's words to a song, which is what I didn't know. And somebody had Venmoed him money, and the whole reason they do it as a joke. The reason for Venmoing you this money is, and someone would say prostitution, and someone else put something that was, Will didn't do it, else wrote something to him that was vile to me. And I asked him about it. I said, what the hell is this? And he said, it's the words to a song.
And then you deleted it.
I don't know if I deleted that. No. Let's be clear about something. That was later. That was later.
So you didn't delete anything then?
With
deleted
racist
stuff later?
lyrics, I didn't delete anything later, but I was made aware that my son's Venmo account was not private.
And in fact, there was other evidence that you saw on the phone as well. including evidence of drugs, marijuana, cocaine. You saw that?
No cocaine.
Just marijuana?
Yes.
And some of these things, obviously, as a mother, you were embarrassed by, correct?
I don't know that embarrassed was the right word.
Upset by?
Yeah, I was concerned. I was
concerned.
Yeah.
And in fact, you were so concerned that you took it upon yourself to sort of take a first pass at that phone before it ended up in law enforcement hands and cleanse the phone of some of that embarrassing or concerning material, correct?
I deleted a few things.
But according to you, none of those things were attendant to text messages that were taken on the, or that were traded on the night of the incident, correct?
Definitely not. I thought those text messages were incredibly important to the case.
Some of the text messages you thought were important, right?
Everything I saw was very important to the case.
You also deleted evidence directly relevant to this case before you handed it to the police as well, didn't you? You saw evidence of, for instance, homophobic comments by your son.
You'd have to show me that. My son has grown up with gay men as mentors, and he is not a bigot. So if you're telling me something, you're telling me something new.
Does he use the word faggot?
No.
Did you see that in his phone?
If I did, I do not recall that.
If you did, you likely would have deleted it because that would have been among the embarrassing things that you as a concerned mom would not have wanted law enforcement to see, correct?
No, I don't think that is something I would have deleted.
You would have left the word faggot in the phone?
Well, it's vile to me. It's not a word I would ever use.
And it's not a word that you would want your son to be known as using either.
And my son is not known for using that word.
Did you ever see any evidence of dishonesty? For instance, cheating on exams while at college?
No. He's worked incredibly hard and is on the dean's list.
So cheating on assignments and or tests, trading information among other students on tests and assignments, you didn't see that on his phone?
Absolutely not.
And you're saying you didn't delete that off of his phone?
If I deleted something like that, I think I would have remembered it.
You even saw evidence of certain criminal activity, low-level criminal activity, but you saw evidence that he had falsified IDs for himself and others. Get into bars, right?
I don't know if Will ever falsified an ID for someone else, but like most almost 21-year-olds, he had a fake ID.
And that fake ID was used for what? What purpose, do you believe?
Buying alcohol.
Getting into bars, right?
He wasn't really going to bars then. He was, but he would buy, what?
When did he stop going to bars?
Stop? I don't understand the question.
You said that he wasn't going to bars then. When did he stop going to bars, Ms. Unruh?
I object to the question, Your Honor.
I don't understand the question. If you're asking me, when my son was a teenager, he did teenage stuff.
Hang on. Is there some reason this is particularly relevant?
These are the items, Your Honor, just to put a fine point on it. This is the last point that I wanted to make with Ms. Unruh before I move on. One of the last points I wanted to make. This is the evidence of scrubbing the phone, of embarrassing.
So you're indicating that these questions go to information you have that had been deleted from the phone? Is that
correct?
Accurate? Okay.
These ended up, this data that I'm referring to all ends up in the forensic data report.
Well, that question doesn't, because he's asking, it's like, when's the last time you beat your wife? That's exactly what this question is.
Oh, that's fair. That's a good point.
I can rephrase it.
Thank you.
You know that the only reason that you would have a fake ID and would falsify identification paperwork is so that he could either buy alcohol for others, or get into a bar.
Buy alcohol, yes.
And you also saw an enormous amount of evidence, I'm supposing, you'll tell me if I'm wrong, on the phone of your son's drinking.
I've definitely seen him with alcohol in hand, as I think every teenager has done.
So you indicated you remember giving a press conference?
Yes.
Obviously. You indicated during that press conference that your son, 18-year-old son, was quote unquote plied, your word, not mine, with alcohol by Kevin Spacey.
Yes, he was.
You know, I object. I don't see what this has to do with the reason we're here for about the phone and where the phone is.
Because I believe that these were some of the data that was deleted from the phone. These are photos that were recovered from Mr. Little's phone. And I can streamline this because it's a late hour.
That because otherwise we'll be coming back tomorrow on this thing.
But just to be clear, he may be extremely. The question about whether she said something about somebody plying you with alcohol has nothing to do with the photographs. The photographs show what they show, or they don't show what they don't show.
Go ahead.
Thank you. I'll mark these for identification only. If I can approach.
Some water.
Yes, please. Thank you.
series of photographs that I want you to take a look at and tell me if you recognize the person in that photograph.
Well, it's hard to tell because he has a hat on,
Right.
but it's probably, I mean, it could be my son if that's what you're asking.
You recognize the shorts, thick shorts, and there's another photograph that may help you.
There, a lot of the kids had shorts like that.
Okay. It looks like there's at some sort of party, and there's a lot of alcohol around, kind of youngsters party, right?
Yeah.
What about that photograph? The second one. See your son there?
Yeah, I've seen my son in this.
What's on the table next to him?
Beer cans. It doesn't make him a criminal.
I didn't ask you if you made him a criminal. I'm asking you if you recognize your son in these photos.
Yeah.
Okay?
I do.
Do you recognize him in this photo?
I do.
Where is he?
Probably at the University of Delaware,
I'm sorry, I meant in the photo, my mistake.
front and center.
At the bottom of an ice luge, looks like a vodka or tequila luge, something like that, right?
Yep.
Consuming alcohol.
Consuming alcohol, yep.
I'm not sure if you see him in that photograph or not. Did you see that on his phone? The body luge photo.
Well, this is not, that is his friend.
Right.
And I don't see my son in this picture.
How about this one?
Looks like he's had too much to drink.
This one, I take a hard look at the shorts.
That's what I'm saying.
They're all different now. Every one of them are different.
Okay.
Those shorts. Is that your son?
That is my son.
So what's he doing?
He is with a bunch of kids on a beach, and they are drinking Bud Light. They're chugging a Bud Light. I don't know what it's called, but there's a name for what you do when you have a hole in a can. And
Punch a hole in the bottom, shake the beer, punch a hole in the bottom of the can and open the top.
I've never done it, so I don't know.
Bless your heart, me neither. Wouldn't want to. But that's what he's doing, correct?
Looks like it.
And in fact,
Those were marked for ID, or were they not?
they were. I didn't even mark them because I'm not going to introduce them. I don't want to. I'd rather not have them in evidence in any way. If the court's record would be cleaner if I marked them for ID, I'm happy to do it.
No, at this point, they're not marked. You showed them. I suppose if you're showing them to the witness, they should probably be marked for ID.
If they are going to be marked for ID, I would ask that the one that she was not able to identify her son be removed from that pile.
That's fine. I can do that.
Thank you.
If you saw those photos, that would not be something that you would necessarily want law enforcement to see your son doing, correct?
I don't have a problem with law enforcement seeing my son drinking.
But in fact, you needed to make sure that the police had a particular view of your son before that phone was turned over, and that did not fit that view, i.e., your 18-year-old boy being plied with alcohol by an older man.
Can you ask me that again? Because
Sure.
I think you're setting it up in a way that
You wanted to make sure that your story, that your son was plied with alcohol by an older man, was believable. These photographs might not play into that story very well.
No, you're
correct?
mistaken. That was not my motivation. I was a mother who was looking through her son's phone for time, and I saw a few things that concerned me.
The fact of the matter is, Miss Unruh, you know, and you knew then that your son had a drinking issue.
He didn't have a drinking issue.
Isn't it true that while he was at college, and I won't even mention the college for privacy concerns, while he was at college, he's already been cited for underage drinking, correct?
I don't know what you're talking about.
You may not know. Let me ask it that way. Are you aware that your son underage drinking while at college?
No.
Would that give you concern if you were aware?
I would object to that, Your Honor.
State.
Ms. Unruh, how many overall, if you were to guess, how many messages, photographs, Snapchats, videos, whatever, did you delete from the phone before
Not a lot.
before handing it over to Trooper Donovan?
Not many. There were just a couple of things that concerned me that I spoke to Will because as a mom, when I see my son doing something that I don't think he needs to be doing, I had conversation with him about it. And so it was an important teachable moment, in my opinion. And I was concerned with the video. I don't know a mom out there who would not have done the same thing.
You mean delete text before handing, or delete data before handing the phone over to the police?
It was not relevant to the case.
Well,
I didn't touch anything that was in the case.
Ms. Unruh, you were not the gatekeeper, were you? The police were the gatekeeper. And God forbid, we might be the gatekeeper or the judge might be the gatekeeper. You understand that, right?
I'm beginning to understand that now.
You don't get to pick, Ms. Unruh, what's deleted and what's not deleted and what the defense sees, do you?
Do you think something 2 years after a sexual assault is relevant to the case?
If the allegations are untrue, every bit of data is relevant, ma'am.
The allegations are not untrue.
We'll see. And you've been advised by your counsel that was appointed this morning that under Massachusetts law that it is illegal to in any way delete, alter, manipulate any object, any data, anything with the intent that that record of that object's integrity is somehow affected before it's handed to the police. That's a felony offense. You're aware of that, correct? Yes or no? Are you aware of
The attorney
that?
has spoken to me about
You
it.
don't need to talk about what you spoke about with the attorney, but if you can answer that question, yes or no.
I'm beginning to see that now, yes.
And in fact, let's talk about the phone. In order to get to the bottom of what was and was not deleted on that phone, would you agree with me, Ms. Unruh, that the very best evidence of that would be the phone itself?
I object to that, unless there's some basis she has in what phones can and
I
can't
gave
do.
the phone
Don't answer
over.
unless
So
the judge tells you.
hang on. You know what? She can testify. I don't know the answer to that. And if that's her answer.
If you don't know, you don't know.
Ask me the question again, please.
You would agree with me that the very best evidence of what was and was not deleted or not deleted from that phone would be the phone itself, correct?
Yes. In hindsight, I would say
Ms. Unruh, let's talk about the phone. When was the last time you saw the phone?
when I gave it to Trooper Donovan.
Were you home when Trooper Donovan, well, you weren't in here, but if Trooper Donovan, apparently you could hear through the walls. If you heard Trooper Donovan testify, you heard him say, hey, look, I walked it back into the house and gave it to Nick or Will, right? Meaning Will Little. Sorry, they're both Will Little. Your son, right?
My husband goes by Nick and my son goes by Will.
Understood. You heard him say, I gave it back, right?
I didn't hear that.
Okay. Did you ever receive?
But I know he does. But I know he does say that.
Okay.
And my husband doesn't recall him doing it.
And my question is to you: did you ever get that phone back from any law enforcement official?
No.
Was that phone ever in the house again after you handed it to
Not
Trooper
to my
Donovan?
knowledge. No. In fact, when it was ordered in the court, I sort of chuckled out loud about it and said, well, that's ridiculous because the prosecution's had it since I turned it over to them. It's never been back in our possession.
Except that you've learned that the prosecution says they didn't have it. They gave it back to you folks.
I learned that.
Did you ever have a conversation with Nick Little about getting rid of that phone?
Getting rid of the phone?
Getting rid of the phone.
Absolutely not.
Did you ever have a conversation with your son about getting rid of that phone?
Absolutely not. No one wants that phone more than we do.
Well, I beg to differ.
No, it's central to the case. We turned it over because it was central to the case, and no one wants that phone found more than we do.
You turned it over because it was central to the case after you were able to manipulate certain things on the phone, correct? Yes or no?
I deleted a couple of
Yes or no?
videos. Well, you're making it sound sinister, and there was no intent on my part.
The answer is yes or no. You gave it to the police after you manipulated the data on the phone.
That is true, and I told them immediately that I had done it. It's not like I was trying to hide anything.
At the time that you handed the phone over to the police, after it had been manipulated, there had been no case filed, correct? Remember, we're talking about
No. There
November?
had been no case filed.
December 18th.
Right, no.
And in point of fact, the case wasn't filed for another year after that. Isn't that right?
It was a long time.
And you knew that the prosecution was going to base its assessment of this case in no small part on the data from the phone, correct? That's why they wanted it.
Sure. That's why we wanted them to have it, too.
I just have one final question about the phone. Miss Unruh, where is it?
I have no idea where it is.
And apparently we'll never know, right?
Objection.
Sustained.
Miss Unruh, one final point that I want to make sure that we clear up. There's been a lot of suggestion the last several days about the dismissal of this civil suit that Will Little brought.
Yes.
And the media has suggested or opined, as they naturally would, maybe there was some secret settlement.
There's no sense.
I object to this entire line of inquiry.
Right. I'm disinclined to get down this road, although I think she just answered.
I think she did. There's been no settlement, correct?
No, there's been no settlement.
Absolutely. That's all I have, Your Honor.
Would you like to know why?
Oh, please, ma'am. Thank you. Ms. Glennie.
Thank you. Now, ma'am, earlier you had indicated that there was a discussion about sending some items to the police, and you said something was screen grabbed from a computer.
Yes.
Tell us, what did you mean by that?
I don't understand it. Will sent me the picture that had the conversation of everything he was saying. And he screen grabbed it from at school. He had told me about the conversation and he said, oh, I think I can pull it up. And he pulled it up and he took a picture of it for me.
Okay, so when you said screen grab, what you meant was he took his phone and took a picture of what was on the screen of the computer.
Yes.
Okay. And is that what was sent to the Nantucket police, if you know?
I believe so, yes.
And it's fair to say you did not delete any text from MD. Is that right?
Absolutely not.
In fact, didn't you say you didn't delete any text whatsoever. Is that right?
Yes, absolutely not.
And with respect to what you did delete, what was it that you deleted?
Do you want me to tell you in detail?
No, just give us an idea. I don't think you need to go into detail, but was it something that took place the night of the event?
Oh, God, no.
So that's what you said. What was it that you deleted?
I think at least a year, maybe more than that after the event. Will would know a better timeline of it than I would. He was partying and he was away at college and he was getting high. He had a water pipe of some sort and he was getting high.
This is when he was left to go to college. Is that right?
Yes. And it may have been his sophomore year. I can't.
So anything was dealing with when he was off to college. Is that right?
Yes. Yes.
Now, do you know how long Will had that was using the same phone that he had on the night of the incident?
I believe it was at least through December of 2016, but more specifically, I couldn't tell you without a record in front of me.
And so if he got a new phone in December of 16,
Yeah.
right? Would he have been a sophomore in college then?
No, I believe that would have been his freshman year.
So is that what you were talking about when the pictures were coming through to the old phone? Because he didn't have that phone then, did he?
No, he didn't. That's a good point. If I were to guess on what I was making that comment, and I'm guessing, but as a mom, I'm probably worried that my son is taking pictures and they're still appearing on that phone. And
now you had indicated that you had the opportunity to access that phone.
Yes.
Would that have been after Will had gone back to college?
Yes.
So did he leave the phone at home?
I can't say that. I don't know because I had it through December 2016. Then that would have been halfway through his freshman year of college. So he would have had it, if I'm right about when he got his new phone, it would have been halfway through his freshman year.
So when you're saying you accessed the phone, where was the phone that you accessed?
It was in his nightside.
At home?
Yeah, at home.
Okay.
I was talking to him at college and he was telling me about the video and I said, where is that phone?
And so you password then?
Yes.
All right. And did you access the phone?
Yes.
And were you trying to find that specific video?
Yes.
Is it at that time that you came across these other videos you indicated you deleted?
Yes.
And do you remember about when that was? What year or what season it was?
I don't. I'm sorry. I know that it would have been in the fall. It would have been the fall of 2017, perhaps. I wouldn't swear to that.
And when you were having some discussions at some point, weren't you, Trooper Donovan, about where that phone may be?
Yes.
Now that would have been after the phone had been taken from you, right? Which you gave it to the police.
Yeah, but I don't think I ever had a conversation with Trooper Donovan about where the phone was after I had handed it over to him.
You don't remember telling Trooper Donovan a box of old phones?
I don't know who I told that to.
But you told it to somebody, right?
Yes,
That
yes.
There was a box of old phones, and that's where you thought the phone was.
Yes.
And you had your husband and your son look for the phone.
Mm-hmm.
They weren't able to find it.
Right.
Did you ever find the box of old phones that you were talking about?
No.
And you've moved a few times, haven't you?
Yes.
Just 2 times, right?
Yep.
And when that happens, you would need to move all of your items and put them someplace, right?
Yes. Yes.
That you even told whoever it was that you told that this box of old phones was in a climate control storage unit, right?
Yes.
And at that time, you assumed that that's where the phone was, right?
Yes.
Thank you. That's all right.
Very briefly, just to clear this up once and for all, you've indicated under oath very clearly you did not participate in deleting any of the text messages from that night, correct?
Correct.
Who's the only other person, to your knowledge, that has a password for that phone?
My son is the only one, but I don't like what you're insinuating.
Thank you.
Well, if anybody had the password, they could access the phone, right?
Yeah, absolutely.
Thank you.
Nothing.
Thank you, ma'am. You missed that. All right, gentlemen, that concludes the testimony, I think.
It does.
Yes. Okay. Again, I'm speculating that, Mr. Jackson, you may want to file a motion.
One's coming.
Right. So file it, support it with your affidavit and the law. And Mr. Glennie, you can file your opposition to it, and the court will then consider that. I'm sorry?
Or not.
Hopefully I'll get it before the Friday before the hearing.
What date are we looking at for?
Your Honor, I'd like to, given what's transpired today, I'd like to proceed with some alacrity and dispatch, if I could.
Come on up. Both of you come up. Would you? All you can come up, please. Okay. All right, folks, thanks for all your help. Let's put this on for a status date on July 31st, and we'll see what happens between now and then. So anything else, folks, to address before we adjourn?
Submitted by the defense.
You know, the other thing, actually, before we go, is the items that Mr. Garabedian offered. You want those? Do you want to look at them? Do you want your?
I don't know if the Commonwealth has them. I think the better protocol would be to go through the Commonwealth and then they provide them to me so it can be bate stamped, et cetera.
I don't have a problem with that. Do you have them at this point? All right, Mr. Garabedian, would you be so kind as to turn these items over to the Commonwealth?
And video?
I'm sorry, yes. And I'm not being flip, Mr. Glennie, but thanks. We good? What do you need? No.
No, not until.
The prosecutor in Nantucket, Massachusetts, has dropped the charges against Kevin Spacey, the actor. They filed what is called a nolle pros, which means they dropped the charges against Kevin S. Fowler, his real name, to Kevin Spacey, due to the unavailability of the complaining witness. The complaining witness took the Fifth Amendment at the last hearing. You just saw Spacey and Alan Jackson go out. Alan Jackson was the prosecutor in the case I tried to a hung jury in California called Phil Spector. Alan Jackson forayed into Massachusetts and did a fabulous job for his client. There was some question whether or not, because the victim's mother had been in the news media, maybe pressure had been put upon the prosecutors and given Spacey's reputation. But the justice system worked. The case against him has been dismissed. I'm Linda Kenny Bodden. Stay with us.